normal course. But if it doesn't reach, your lordship will kindly accommodate us for 5 minutes as per your
At
lordship.
two?
Yes,
At
ma'am,
two.
at 2.
Oh.
And my lord, we all have come to move some urgent motion for tomorrow. There is a convention that normally motions are allowed on the last day. So
We are
we,
not allowed.
your lordship will kindly permit us. We'll take a chance tomorrow because most likely all the motion will be distributed to
all the benches.
all the benches, my lord.
I'm
But
not,
since
I'm not. You just approach the registry is distributing even if now. So we are not allowing.
No, your lordship will kindly grant us the permission. The registry will distribute. Your lordship, because
No.
I,
Sorry. I'm leaving tomorrow a bit early, in fact. We will
Oh.
not be possible. So you may approach registry. There may be a supplementary that may be accommodated. That may be accommodated.
the bail petitions are distributed amongst all the courts because now it's a say almost more than 10 days
10 days.
holidays. So that
How 10
is
days holidays? 8-9 days only holidays.
no, my lord,
What
from
is this?
12
What is the
till
case behind?
22nd.
It's not so urgent, no? Not
Yes.
so urgent.
we'll
22nd, why
approach-
22nd?
20, sorry.
Yes,
Okay,
20 up to
yeah,
20 only.
yes.
21st. And 12 and 13 is normal holiday. Normal holiday. Yes. If can be distributed, then it's
Yes, ma'am. Yes.
My lord, similar pair listing for tomorrow, filed on 8.
no list. Just same thing.
May please, your lordship.
Mr. Chaudhary, yesterday what had happened, one matter was there in item number 25.
Yes.
So why you have suppressed the matter? That matter was earlier rejected by the Justice Pathak, the senior bench. And the recent notification also says that if it is rejected by some senior bench, then it has to be go there only. So why you have suppressed the matter?
Not suppressed, madam.
Then-
I have mentioned it.
Well,
I have mentioned in the petition.
in the petition,
Perhaps, my lord, I have to see, my lord. Actually, earlier, my lord, this case is newly assigned to me by the client.
earlier who was the youngest counsel?
It was not that.
And why the office, suppress? They should not place it. If it is once rejected by the senior bench.
Cannot be lordship.
This cannot be.
If it was mentioned in the petition lordship, there
Ah.
is no way that the registry will make that mistake. It cannot be lordship. If they had
That
mentioned it,
he is sufficient, I don't know. If it is there, as per you have mentioned.
I have to check it, my lord. Otherwise, my lord, newly assigned me, madam. Earlier, I was not the advocate.
I have checked the order. You
Even
have
then-
earlier ordered the counsel, and this counsel was someone else. most
I
probably.
think.
You are not the
I
counsel,
am not the counsel.
but you
even
should
then,
take the,
even then it is the duty of the lawyer lordship. to
yes,
See the such details lordship regarding the case. It is his duty.
obviously. So we'll pass the order. It will be listed before the appropriate bench. Yesterday's item number most probably 25 was there. Don't mislead or don't suppress the matters. Just come forward with a petition. We are trying to accommodate all of you.
Yes.
It's not the case that we are not, we are trying. It's not the case that you should suppress someone. And nowadays, most probably you have to, in your petition itself, if earlier cases any pending against you, that has to be mentioned to see your criminal antecedent. That is also there.
My lord,
Please,
this today's listing, my lord, similar matter, my lord, out of same FIR. It is listed, my lord, in item number 9, court number 21. So being the senior bench, my lord, I mentioned it, this matter may be listed with item number 9 at court number 21. Similar matter,
Item number 9.
9 of court number 21.
Ah.
So this matter may be listed with today with item number 20, item number 9 of court number 21. My. Go ahead.
Yes, lordship. Lordship, criminal representation 35/25. Kindly matter may be taken up tomorrow.
Where is the criminal revision? You have filed.
No, lordship, this is the order letter. Already notice has been served, your lordship. And
No,
on the last court, you will not reach in this case.
sorry. No matter will be listed.
Then, lordship, one day.
No listing will be there. That's what I'm saying. You just
Any
approach the
debt may
registry.
take- any
You
debt
just
may-
approach the registry. It can be.
Lordship, any debt may be fixed.
No,
21 may-
that apart you.
21
Number
is
very-
there,
18. You make a mention before court number 18.
18. Okay.
Yes.
Obvious.
I have a small prayer, Milo. In item number 11, Milo, there is a pagination, Milo, there is a, I need to just paginate. There is some mistake in the pagination.
Ah.
I may be allowed to correct it. Item
Correct,
11.
you cannot correct
No,
that.
Milo, only thing, Milo, the pages, Milo, the first page went second, Milo, that is one.
Oh, আচ্ছা, okay.
Small one.
You corrected pagination is. But Mr. Day, not the order. The copy which have been supplied to the state, you just check for.
May it please your lordship, in item number 30, your lordship, we have filed an affidavit. But it has not come on record. Kindly allow me to bring it on record, your lordship.
Affidavit.
Yes, sir. Oblige, your lordship.
May I please your lordship, I'd like to mention, BA 2147, 2024, it was pending from last 10 months, your lordship. I was newly engaged in this case. Your Honor, kindly list the matter tomorrow. He was
No
behind
listing.
our-
That's what I'm saying, no listing.
May I
No
please-
listing. You may make approach with your registry if it is there.
I'd like to
Right,
mention
please.
item number 10, your lordship. Kindly matter be fixed on 7th of May, your lordship. There's the entry, your lordship. The engaged counsel Jadaram is out of station, your lordship.
But we have received here, it's a fixed matter. We have received here, case diary, you know. This case they received. So they are seeking time through 7/5. Can it be possible? I have to send back the case diary. At the request made by the learned counsel for the petitioner. Case is adjourned, however. It is submitted by Mr. Goswami, the learned additional PP that CD received. CD will return accordingly, call for the updated one. List according on 7/5.
7th of May. Oblige, your lordship.
May I please? Lordship, this is an anticipatory bail application, fresh matter. Lordship, can it be tomorrow?
No listing. Just I'm saying that one. No listing. No listing. And we have been leaving early. I have a flight in fact. We don't have. Don't.
Since my matter is pertains to negotiable instrument, lordship, and I am behind the bar, lordship. Therefore, maybe
What kind of matter?
of
It's a bail or what?
application?
No, that's what I'm just repeatedly I'm saying, it's
But-
not listing. You just make a approach before they registry it. If it can be listed or if it subsequently charges, it may be distributed to the other courts also. You just, we are not listing.
Lordship, I beg to mention item number 19. There, my lord, trial court record has not been received, so if it can.
1/9.
1/9, my lord.
Here also, have you suppressed anything
No, madam.
to check otherwise?
Trial court.
Trial court record is not yet received.
Not received, madam.
Issue remind, submitted trial court as per office note, the answer has not yet been received. Issue reminder, registry will do the needful. List accordingly, the charge sheeted case,
Yes, my charge sheet and evidence also recorded to entry.
list accordingly on. Scan copy along with CD. Scan copy along with CD. List corridor. When can be listed? After being vacation will do.
Yes, madam. As per convenience of this court, madam.
Immediately after vacation on receipt of the LCA,
Madam, can it be on 30th of April, madam, if possible?
after vacation.
May I please your lordship, BA 2147, after vacation, lordship. Maybe listed after vacation,
Okay,
21
21.
of the lordship.
May I please, your lordship, lordship, I beg to mention for listing of regular bail application for tomorrow, lordship.
Tomorrow, that's what I'm repeatedly saying, no tomorrow.
I'm sorry, lordship.
Okay.
For withdrawal, item 32 of the supplementary list.
So, and again, more of a doing question. I don't have an order. How can be possible? I will also have time for the other one. It's not possible, no, on our part. We are living absolutely by effort, right? There was so today and again, can I? We are not in a position. That's what we are facing some trouble. Dealing with the. Yes,
Withdraw your lordship.
Huh?
May I allow for withdraw your lordship.
For withdrawal, item 32.
item 32. Election petition is also there today. So as per instructions of your client, you
Yes,
want to
Lord.
withdraw? Hard MS emailed him, the learned counsel for the petition, and as per instructions of his client, of her client, she wants to withdraw the same. Prayer allowed, disposed of on withdrawal. Okay, it will be disposed of on withdrawal.
Oblige.
Daily list item 1.
May it please the lordship. Yes, my lord, I was arrested in this case on 2924, my lord. And charge sheet has also been laid on 28, my lord, on,
You were arrested on 2/9.
yes, my lord,
24.
2924, my lord.
Hmm.
And charge sheet was laid in this case, my lord, on 10/2/2025. And my lord, the next date, trial court has fixed for supply of documents, my lord, on 23/4/2025. Now, my grounds for pressing this application is on the basis of annexure 5, my lord, which is at page 38. Lordship will kindly have a look, my lord.
Annexure,
Annexure 5, my lord, page 38. To petitioners before your lordship. And I have also, my lord, obtained the certified copies for my lord's perusal.
how many petitioners? We are
Two petitioners are before your lordship, my lord.
one is Lal.
Yes, my lord. And the notices other things, my lord, does not indicate as to the requirement as held by the DNSS and Constitution, my lord. So my fervent prayer before this honorable court is to consider my prayer, my lord, by imposing any stringent condition. It's a defect. And 9,
It will take this. Just we are checking.
yes, ma'am.
It was not rejected by me.
As per the e-code, my lord, it shows 23/4/25 for supply of charge sheet and copies.
First, submitted very recently, 10 to 25.
Earlier petition was disposed of by justice.
Yes, it is Annexure 3, my lord, page 24 and 25 of our applications. Because charge sheet was late, my lord, so they were, my lord, withdrawn it was. They were directed to approach it advisor. Page 25, lordship will find, my lord.
Yes, Gusam, you want to say?
No, it's a fully commercial quantity methodology. And after need to be what Shasik submitted, several sufficient materials are there, that's why I have submitted such reflection. Very initial stage of trial, otherwise.
আমি চৌধুরী বিধানসভা কাউন্সিল for the petition. এবাৰ ললে লগতে উল্টা পুল্টা হেৰি নকৰিব ডিটেকশ্যন দিছো মানে এইটো আপোনাৰ ওচৰত যাব ট্ৰাই টু টাইপ হাৰ্ড মিষ্টাৰ এম এ চৌধুৰী বিধানসভা কাউন্সিল for the petition.
Only on this ground only, otherwise other grounds not.
And also had Mr. T.P. Goswami, the additional PP appearing on behalf of state respondent. This is an application in section so and so, condition with so and so. It is submitted by Mr. Chaudhary that the present two petitions got arrested in connection with this case on 2/9/2024. And case has already been charge sheeted on 10/2/2025. 10/2/2025. But at the time of 2025 and both the accused petitioners are innocent and nothing has been recovered from their conscious position. Further, Mr. Chaudhary submitted that at the time of their arrest, the grounds of mention were not mentioned either in the notice under section 47 BNSS or in the arrest memo under section 36 of BNSS. এইখিনি লিখি বাকিখিনি মিলাই দিব পাৰিব নহয় এখানে দিয়ক গোস্বামী দিয়ক আৰু মিষ্টাৰ গোস্বামী the learned additional PP submitted that the case is at the very nascent stage of trial, at the very beginning, trial is not yet commenced, and the case was charge sheeted only on 10/2/2025. From the FI and the forwarding report, etc., it is seen that the recovery was from the conscious position of both the accused petitioners. More so, this cases of commercial quantity and hence the record of section so and so will follow. বাকি এখানে মিলাই দিব। হবে না? Okay.
Very pleasant, Lordship. Lordship, item number 37 of supplementary list. Yesterday I was mentioned for withdrawal, but it come up for listing of a bail hearing, Lordship. So some technical difficulty, Lordship. I
You want to
have
withdraw this one?
Yes, Lordship. Item number 37 of supplementary list.
Do you have any other prayer? Here,
No, Lordship.
just went to
Yes,
withdraw.
yes.
You're Mr. D. Sharma
Yes, Lordship. On behalf of S.J. Sohoria.
on behalf of,
S.J. Sohoria. Behalf of D. Sharma, I appear in S.J. Sohoria, Lordship.
you are S.J.
S.J. Sohoria.
S.J. Sohoria. Heard Mr. S.J. Sohoria, 37. Heard Mr. S.J. Sohoria, learned counsel for the petitioner appearing on behalf of Mr. D. Sharma. And accordingly submitted that as per the instructions of his client, he wants to withdraw the same. Prayer allowed, disposed of on video.
Video, please.
Item 2.
In this case, my lord, three persons are the accused, my lord. Out of them, accused number 1, my lord, page 49. Page 49, your lordship disposed of bail application. Page 49.
Co-accused. Co-accused.
Number 1. And I am, my lord, accused number 2. Page 19 is the FIR last person. Three persons were arraigned as an accused.
His bill petition was also earlier rejected by someone.
No.
Your petitioner.
This is new one.
Is there any earlier rejected order by the coordinate bench?
This court, this accused number 1, my lord, disposed of by your lordship, page 49. And I am accused number 2. We have to go to record. And arrest memo, my lord, I have next page 46, 47, and 48. Arrest memo, inspection memo, and notice under section 50.
Your petitioner's name is?
Ian Cookie.
So we have a next one, order at page 43. What is this?
Page 43, accused number 3, my lord. This is accused number 3. Earlier rejected by accused number 3, my lord.
You are accused number 2.
And accused number 1, my lord,
Was already granted.
granted my by your lord.
I pay for also records at this stage.
And accused number 1, my your lordship granted bail even without polling records. This is on part of April, my.
Forty-nine of answer date. Page number 49. or co-accused আছে না? তাই মোটামুটি একটা মাইলে হলো। Any other extra submission from your side?
My
Same.
This arrest procedure now, at present, I am paying bail on ground of arrest procedure. And the accused number one was granted bail. So parity and arrest procedure, these two grounds, my lord. Now,
Yes, Sami, any submission?
my humble gratitude, we are already on relying their documents, we are not also done winners of bail. At least one son should be given to us, but go through the records. At least. Because it's a heinous crime, Lordship. We don't go through the records, Lordship. At least to the prior Lordship, we want to verify the records, Lordship, and Lordship also please the records and didn't country the problem. We are always we are relying on their documents and Lordship also granting release the bail, Lordship. And my humble subject, we have to go through the records and after that, Lordship, dispose it of also. It's my humble gratitude, Lordship.
Yes, any submission? Sir?
My lord, my humble submission, this is the original certified copy. These are I have my lord. Page arrest by page 46, 47, and 48. If your lordship go through, my lord, and the accused number one, my lord, is granted bail on the same ground.
So obviously, Mr. Kusami, there are some reasons. But the question is that these are the certificate copy and the notice which was sent to this one with the signature of the arrested accused persons. So that is the only reason actually, in fact. Otherwise, because we are not on, at this stage, we are not dealing with entire case on merit. So only those
Only because of
two,
that
three
job.
of these law points only. So that's what we are saying. Otherwise, definitely it's a case of very heinous crime. We are also feeling that now.
Very unfortunate for us also.
Very unfortunate for us, very unfortunate for us. We are, if the accused entitles for bail on the merit, that is question is different, but otherwise they're taking that chance and opportunity and they enter.
You are helpless.
All the veteran criminals have already been out. So let's do, let's hope for the best in the next following days. If we get the proper arrest memo or proper notice, it will be a lesson for the police authority also.
And about 1 year he is in detention.
When he got arrested? He got arrested on? Earlier one was arrested on 28/3/2024.
Yes, I was arrested also 28/3/2024.
Same.
Same.
The order, page number 50 from my place. Oh, yes.
Item 3.
May please, your lordship. My lord, NDPS, my lord, nothing was recovered from their possession, my lord. Page 14 is the arrest memo. 1/4. But my lord, there are two accused person. This arrest memo is for accused number 2. The other one, my lord. You don't have to go to the arrest memo. Go back. Go back. Accused is an arrest memo. Okay, my lord. Lord, I'm sorry, my lord, while preparing the bail petition, the arrest memo for the other accused could not be annexed, but this is the, for the other accused.
Only arrest memo are there, for notices. Notices are also. there.
My lord, since notices are not there, your lordship will call for the case that I'll not. But I know, my lord, that 47 notice also grounds of arrest are not there, but still for the courts, yeah, your lordship will call for the, or your lordship, I may get a certified copy by today itself and file an additional affidavit and get it, can bring it on record by tomorrow, my lord. I can do it on my part, subject to your lordship's
Tomorrow
convenience, my lord. If your lordship wants to
Repeat how many times I'm going to repeat? It's bad. Yes, soon after, in the, immediately after vacation, I needed them.
21 तारीख को
First, I would get another needs.
rest that to bring those on record, that I'll do it. I will do it, but your lordship, I'll not burden your lordship, because I can understand, my lord, the lists are over. 22 तारीख did
20? 21 we can say. Okay, 21. All police can fulfill the case record along with the case diary.
No, not record, my lord. It is investigation stage, my lord.
Still in the investigation.
Investigation, let them CD.
Case diary.
Oh, case diary.
Along with
Okay,
FSR.
okay, I thought it's charge sheeted one. Okay, then. CTB call. 21.
And petitioner is at liberty to file an additional affidavit bringing on
Yes,
record.
we will accept it. No issue.
I'll do it.
I just hold.
May I be the lordship? First, I'm going to the FIR, my lord, page 21.
Page 21.
21. Page 21, and the 11 page on 27. 27, my lord. Stated around 6 months back that below cited accused person certainly took relevant paper and document from Anup Deka, Pallab Dwara, Dipankar Deka, Uddhav Deka, and me saying that they would procure scooter in our name from the dealer and would pay an amount of 300 per day. Each of us, they submitted a paper and document to the dealers and took deliver the scooter in our name. The accused person took deliver the scooter from the dealer but did not act as per their promise. Now the dealer issued notice to us stating that we have not paid installment for the scooty. When we went to the house, the accused person asked them about the matter. They sent us back by making threats. This suspect accused person has sold a scooty issued in our name by the dealer to other person. I therefore urge you to your good self to be kind enough to take necessary actions against the accused person or ambulance. My lord, if you go to the FIR, my lord, first I'm telling you, my lord, it's civil dispute. Total civil dispute. Not what section they have added, my lord. I just read out, my lord, the sections. 316.2 BNS, 318.3 and 3.5. 318.3.5 is all, these are bailable offense. Only 316.2, that is a criminal breach of trust. But what from the criminal breach of trust comes out? There should be an entrustment of property. They are not there. Now, my lord, another thing, one important point, my lord, they have violated the entire thing, my lord, the entire Supreme FSCO decision police manual. I have stated in my para, my lord, in para 4. The accused person father begged to submit that thereafter during the course of investigation, he was arrested by on 21/3/25. At the time of the arrest was prepared by IOC Swapnil Mili. A perusal of the arrest memo would reveal the accused person was arrested on 21/3/24. My lord, if you lordship go through the arrest memo on page 34. Page 34. Time and arrest 21/3/25 to 1:20 p.m. Now, my lord, what happened? I just read out, my lord. An inspection memo was prepared by IOC Swapnil Mili on 21/3/25. A further under notice under section 48 of BNS was also prepared by Swapnil sir upon the brother of the accused in one thing MD. Additionally, it will pertinent to mention, although the arrest memo dated 2023 shows the arrest was made on 1:20 p.m. However, much to the contrary reflected in the said memo,
The accused was taken into custody from his brother's residence at Guwahati around 3 a.m. before sunrise. He was picked up from his residence at the mid of night, and this is why I just show my lord one documents. Although I have not any, later I got that their document. It proves that they have taken his custody at middle of night. One is and now, my lord, just read my lord. I, Sri Manas Pratim Sharma Mongolda, do hereby take our custody of Sonipur Shimri from his brother, namely Atin Shimri, for investigation purpose. We won't have him in our custody. We won't have him and take. We don't harm him in our custody and take much care of him. That means he was picked up. This from his residence at 3 o'clock morning. My lord, one thing. Second, my lord, what happened, my lord? When he was arrested, he was produced before the magistrate. And magistrate learned CGM, as I have annexed that documents also, they want 5-day custody. And what is we have then, when I filed a bail application there. In the bail application, I have stated 2 grounds. What are the grounds? Non-compliance section 35(3) of BNSS. Because in that case, my lord, because since the punishment of 363 is below 7 years, the section 40, the previous section 41 is notice mandatory, which is not given to him. Under Kumar judgment, my lord. So he had immediately, he was arrested before serving any notice. Second, that violation 22 of 1 of the Constitution of India. But my prayer was rejected, and he was taken into custody for 5 days. Police custody. He was kept in the custody for 5 days. Later, he was produced again on 26/3. On 26/3, police said that no, we father don't need any custodial detention, so let him send in judicial custody. So now this custody is over. They don't want any. What is the question of keeping him custody for a long?
He took the accused for police custody for 5 days.
5 days.
And after completion of 5 days,
Yes.
he was produced or before?
Only if he was produced.
No, after completion or before completion?
After completion. I just read out that order also. Page 41. Investigating officer, Sub Inspector Swapnil Mili, I just read that for 41 page. Investigating officer Swapnil Borua, you got it, my lord?
40.
41.
Hmm.
Investigating officer Sub Inspector Swapnil Mili of Mongolde PS has produced accused person namely Soerempam Shimre, 34 years, and Jintu Deka, 23 years, after completion of 5 days of police remand period. Along with accused forwarding report, medical equation, seen all the course, connected paper, and heard the accused person. Accused Jintu has stated that he is well and has not made any complaint of whatsoever nature. But accused has stated he has stomach problem and hepatitis. That is my client, my present petitioner. And hence the jail doctor directed to examine the accused, give proper medical to him. Learned defense counsel for the accused have appeared and filed her. Learned defense counsel for accused has also filed Vakaratu hard learned defense counsel. Let both the accused person be remanded to judicial custody. So he was sent to judicial PSC's police have not given any objections. So what is my submission that 4 things I have highlighted, 3 things. One, they have taken into custody at 3 o'clock midnight. That too without serving any notice under previously section 41A notice, 30/3. Second, my lord, the violation is that, my lord, here that at the time of arrest, the ground of arrest was not mentioned. If you want to go through the arrest memo, why he was arrested, it is not given. That is not given. You will have to go through the arrest memo. Page 34. Page 34, the arrest memo, that what ground of arrest was not, which is mandatory, was not explained to him. Third is that, my lord, that he was already taken into custody. And in 5 days, custody interrogation is already over, all interrogation completed. So, my lord, at this stage, there is all Supreme Court decision, I don't want to quote, my lord. Supreme Court says, instead of, this is not a jail, this is not a this is a bail, not a jail. So people should not be kept in jail for a unnecessary period, unnecessary detention. They should be released on bail, my lord. It's a simple breach of trust or something which is not even proved also. And breach of trust, that will be in a trial, it will be decided, and it's civil nature case, my lord. This is not submission, my lord. He should be released because already how many days in custody? 20 days in custody already. So that I think it is sufficient for him because already police didn't want any further interrogation.
Yes, Kusam.
Yeah, but we have submitted to some relevant documents from various persons and bought some scooters and motorbikes from various dealers from their names, and after they are not paying the EMIs. So sufficient material, maybe materials and this is organized crime or the nexus will be there also.
This is my lord, that is what they have paid instrument or not, that is pure civil case. Let them go file a civil suit. Yeah. The dealer didn't state anything. They are not filed any FIR that I have not received. It is an allegation of one particular person. Who has FIR, law than FIR, particular person.
In the case there, yeah, then it is very difficult to say that.
Already police interrogation is case there already. You have explained, my lord.
And accept the procedure, I prefer case there. Otherwise, the arrest memo regarding the arrest memo.
He will release, my lord, man, unless he is kept in jail.
Heard Mr. S. Mitra, the learned counsel for the petition, and also heard Mr. A.P. Goswami, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. It's apparently submitted by Mr. Mitra, that counsel for the petition, that present. You are two petitioners for one. This petition is for one. Present petitioner is innocent and he is no way involved in the alleged offense. Further, from the plain reading of the FIR itself, it is seen that it is a case of civil in nature and party can approach the civil forum for proper redressal. Mr. Matra further submitted that there is a violation of section 35 BNSS and without issuing any notice, the present petitioner was picked up from his house at about 10 AM and subsequently arrest memo was issued on 1:20 PM. Further, he submitted that after his arrest and his production before the judicial magistrate, he was he was taken for 5 days police remand. And after completion of the 5 days police remand, he was produced before the learned trial court below. And accordingly, and since then he is in judicial custody. I have got sufficient time for his statutory interrogation as he remained 5 days police custody and police custody. Next para. Mr. Motro further raised the issue that there is no grounds of arrest mentioned in the arrest memo vis-a-vis any this issued to him under section 47 and notice issued to his family under section 48 of BNSS, which is in violation of Article 21/22 subsection 1 of the Constitution. Mr. Goswami, the learned additional PP submitted in this one that at this stage they denote the actual fact of the case. His diary may be called for, and it seems that it is an organized crime wherein they take by taking some papers, they took some the vehicles on hire purchase and subsequently sold it to someone else by not making any payment of the EMI. However, he submitted that the points raised by the non-mentioning of ground of arrest. Not like it. Is that it? But he insisted to call for the case study. But he never did. Okay, we'll see it.
Call for case study or call for?
We are passing in the order, you see, but it may be disposed of also.
Item 5.
Yes.
With Procedural Lordship. This is regular bail application Lordship. Lordship will find the FIR is at page 8 Lordship. Here in this case, Lordship, the allegation is that the victim and all the person named in the FIR are minor, except the petitioner who is a 19 years old. They, after playing cricket Lordship in a field, Lordship, they went for swimming Lordship. And during swimming Lordship, they made fun for each other Lordship. And some photographs were the video recording was done one of the boys Lordship, and it was viral in the Facebook Lordship. That is the allegation. The petitioner Lordship, only allegation against the petitioner is that he threatened one of the boy to have a sexual activity with the victim Lordship. That is the allegation Lordship. Here in this FIR has been registered under section 4 and 14 of the POCSO Act Lordship, but none of the section attack against the petitioner Lordship, because 4 is talk about sexual assault and 14 is using child for pornography Lordship. None of the ingredients of this section attack against the petitioner Lordship, so far as allegation made against him in the petition Lordship. There are 7 numbers of accused in the name in the FIR, except petitioner number 1, who is a 19 years old tender aged boy Lordship, and another all are remaining are juvenile, and they have been already released by Juvenile Justice Board Lordship. Allegation. An allegation against him only that he threatened someone to have some bad thing with the victim, son of the informant, that is the victim. And if we accept the allegation Lordship, then that is not also attack the section 4 and 14 of the POCSO Act Lordship against the petitioner, who is in custody for 20 days Lordship. And he is aged about 19 years, remaining a juvenile, already granted bail Lordship. Petitioner name is Vikas Roy, and he threatened the only reason after coming out from the pond, the said 2 boys threatened my son and one Nitish Roy and forcefully tried to engage them in sexual activity. Because
Yes.
after going to the FIR, we have this FIR having no other alternative and fear of death, the said so and so committed sexual act with my son, and which was videographed by other boys. After they made the video viral on Facebook and WhatsApp.
it is against one Nitish Roy, not against the petitioner Lordship. The Nitish Roy have sexual bad act with the. Nothing has happened because they all tender-aged boys, they made fun for each other in a coming out in the pond, and all are only except the petitioner remaining are juvenile. A petitioner is also 19 years old. So far as section 14 and 4 and 14 in COSAC, that is not attractive, because 4 talks about sexual assault, that is also not attractive against the petitioner, and 14 using child for pornography, that is also not come in this case.
Paper case day and POCSO
Yeah.
notice to go.
Now he is 20 days Lordship, he has in
Issue
middle
notice
custody.
for it. It will not issue notice to the respond number 2 through the additional police station, which to the office of the registry and the public prosecutor. Also call for the case time. You take steps, list when it can be listed.
22. Lordship, 22 Lordship.
22. 23. She is saying 23.
Obliged.
Item 6.
This is a application under 438 LDPS case, my lord. And opium has been seized. Opium. Waited for the. 1.028 kg. This commercial quantity, no doubt, my lord. Then what happened, my lord? Here, my lord, if your lordship go through the FIR, he is a co-passenger. He is a co-passenger. So lordship go to the FIR, my lord. 26. 28, my lord, page 28. I just read out, my lord. We refer the subject cited above. I have the honor to inform you that today on 4 to 24 around 5 AM as director, I along with GRP personnel, namely so and so, so-and-so, left for checking duty at Guwahati. After arrival at train number so-and-so, was conduct checking of bag of passenger in coach number A2 in due course. When we are about to check luggage bags of the person sitting in seat number 1, 2, and 3, the person became nervous. On inquiry, they disclosed that they were traveling together with Dimapur and identified themselves Gurnel Singh, Sher Singh, and Jasbir Singh, so-and-so. On checking their luggage bags, we found 3 packets wrapped with brown color plastic tape containing suspect opium inside a blue color trolley bag. From the position of Jagdish Singh and also found another 31 packet wrapped, 1 packet wrapped with brown color plastic bag. So-and-so. As the train was about to depart for its destination, we brought all the aforesaid person and belonging, which include 1 flat screen television packed in cartoons. Accordingly, I have informed the matter to GRP through a phone call, after which SI Rafiq Ali of GRP arrived at the PO. After arrival so-and-so, we checked the aforesaid flat screen video screen, which is packed in carton owned by so-and-so, and found 5 packet wrapped with brown color plastic tape containing suspect opium inside the screen. During question, they revealed that carried the aforesaid packet of suspect opium from Imphal, Manipur, and they can save it to a native village with a motive sale. Hence, all so-and-so waited the aforesaid packet suspected opium, and subsequently seized the same contraband in present. Therefore, I request to kindly read. Oh, my lord. In this way, madam, so, my lord, after that, he was arrested. Why I have challenged, my lord? This, which is the important thing, my lord. First, he was arrested on 3/4/24. And accordingly, he was produced before the learned Chief Judicial Magistrate, learned Judicial Magistrate First Class, remanded accused petition judicial custody. Since then, he was languishing in jail. Then, my lord, he moved a bail application before the additional session judge, additional district session. He rejected bail application. Accordingly, the charge sheet has been framed. Charge sheet filed on 36/24. On 36/24, charge sheet has been filed, and court take cognizance on 12/7/24, and it was registered as NDPS case number 238 or 24, pending before additional session judge number 3. After that, my lord, if you also go through the page 11,
How many witnesses examined?
only just written, only 3 were witnesses were examined out of 11.
Out of 11.
After 11, 3 were examined, and he is in languishing jail since 2 to 4/24, at least 374 days. 374 days. And from, if you also go to page 11, my lord, page 11, I have given the chart of entire case or detailed court order. What is the position of particular date and what happened? In most of those cases, I find that no witnesses have turned up. No witnesses have turned up. Only 2 P were examining, prosecuting witnesses were examined, cross-examined, and discharged. No witness turned up. In this way, the date was passing date after date, and he was languishing, and no witnesses turned up. So, I don't think that it will take some time, my lord. So, for that reason, he should not be put in behind the bar. For that, so many, already he is in custody. And my lord, what is the reason, my lord? If you go through the reason, if you also go through the arrest memo, you will find, my lord, why what is the total nowadays? What happened? What is the violation? The reason for arrest was not mentioned. Why he was arrested? And I have stated, my lord, there are so many violations, my lord. Particularly, para 3. Para 13, my lord, page 18. I just read out, my lord. The accused petitioner further begs to submit that at the time of drawing a sample, a mere procedural order dated 3/4/24 will reveal that LS since contraband was already in homogeneous mixture of 8.24 5 kg, and for which 2 samples of 24 grams each was drawn. The same being violation of Rule 10(2) and 3 of Narcotic Drug and Psychotropic Substance Seizure, Storage, Sampling, Disposal 22 rules. Since the mixture homogeneous were not made in presence of magistrate, and therefore the same being a violation of mandatory statutory rules. So this is one of the ground. Another ground, my lord. The accused person further begs to submit a mere page of seizure list would indicate that alleged contraband recovered from the accused petitioner is 1,200 kg of opium. In this case, the accused may only submit that a contraband opium is mentioned under serial 92 of table so and the commercial quantity said weighs 2.5 kg. This I will either 2.5 commercial quantity is 2.5 kg. Although the case has been registered and the charge has been framed under Section 20 NDPS, however, nothing has been found in the charge sheet of any material relied upon by prosecution to lay the basic foundation that there was criminal conspiracy between accused petitioner and the other co-accused. And in this way, my lord, here in this way, so after reading through the FR, the 37(1), that is draconic section 37(1)(b), I think it will not applicable because he is not a proclaimed habituated offender. And for the first time, I think he has been caught. And already he is in jail for last 27 days.
Item number 6, in the site I'm supposed to look for. Nothing seized from information. 4 passenger. No constant person. Present jail has since 3/4/2024, 3/4/2024. CS submitted on 30/06/2024. 3 witnesses examined after 11. Custody since more than 1 year. Main grounds 50 CRPC and eligible. Yes, Gusami, and submission.
Lordship, if he is
Otherwise, it's a
submitting on,
case of opium,
Lordship,
but
Lordship, if he is submitting on merit, then I have to call for a records. If you are on the procedural lapse, then I will leave it to you, Lordship. Otherwise, out of 11 witnesses, 3 witnesses examined, only 3 witnesses, and 8
it's
we have
not
to
a
be
case of
examined.
inordinate delay.
Lordship.
It's not a case of inordinate delay. 3 witnesses are already been examined out of 11 witnesses.
Already he is in jail for
And
340 years.
probability of completion of trial is within reasonable time.
And there is
So
recent
can be
critical decision also, my lord.
expected. Or Baki is adopted. Okay.
Record call, my lord.
No, we will dispose of. it.
Okay.
7.
Only 25 to re-record. 25 to remove. Oh, sorry, some of
May it please the
Yes.
lordship.
Yes.
Lordship, this is a regular bail application filed by the petitioner who is behind the bar since 6/9/2024 and till date 2015 days has been completed in the detention
6/9/24.
24. And he is the owner of the vehicle, lordship.
So, Shas, already Shastra Lordship, records will be called for this.
Case is charge sheeted 1, I think.
Shastra.
He is the owner.
Okay.
Don't know whether owner is associated with the case that is not known. to
But
us
he
at
was
present.
not taken, he was not apprehended immediately because the driver who was apprehended along with the drugs, it was dated 4/4/2024. Thereafter, after 5 months, when the owner of the vehicle went for the Zimma of the vehicle, thereafter he was arrested. Why 5 months?
Maybe CS number 10/24, dated 16/9/24, Shastra submitted. What is the stage of the case, Lordship? We have to go through it also, for the records at this place.
Okay, that may be, he may be simply owner, but if suppose any secret chambers were there or other things are there that owner may be associated, we cannot say at this stage. That is the main issue.
29 is also there.
So 29 is also there. So we are calling for the case record. It will be reached immediately after view. Immediately after view vacation. The new vacation on receipt of the case record along with the case record. Okay, we are calling it. Date we cannot give. If it pray for date, then it will go the month of May. Otherwise, immediately after vacation. Much obliged.
Item 8.
Please, your lordship. So this is a regular bail application and the case is searched. Already, two of the co-accused have been granted bail on the ground that there was the grounds of arrest were not mentioned. I am also claiming the bail on the same ground. I have annexed the arrest memo that is at page 18. Two arrest memos were there. Originally is at page 19 and another one is at page 21. So no grounds has been mentioned, and this was the findings of this honorable court in another case of the co-accused that I have annexed the order. That order is at page 94 and relevant portion is at para 10. Then your lordship has discussed the various judgments and ultimately granted bail on the ground that and charge sheet was filed on lordship 31/10/2024 and they were arrested on 6/6/24. Until now, no witnesses have been examined. Search frame. Search frame. Search frame, but not search framing order is that I have annexed. I am on the ground of non-compliance of section 50 of the CRPC. That is the ground of arrest were not mentioned. And parity, I am claiming parity because the co-accused has been granted bail by this honorable. Two of the co-accused has been granted. That I have annexed both the orders. That is at annexer 12 and 13. At the order of this honorable court. Your lordship has passed these orders.
The 94 is of co-accused.
Lordship.
Page number 94 is for co-accused.
Yes, lordship. Arrested in the same case. Para 13, lordship has mentioned about the non-mentioning of the ground of arrest there. Here also the arrest memo shows that there no grounds has been mentioned, only case number is mentioned.
Yeah, the one we had as the order to receive of this can copy of this. But here that part was not necessary. Other things may be all of the same. And his submission two of the accused persons have already granted it and considering the case of the present petition on the same footing. And he also will be allowed to go on bail on the ground of parity. And because of non-compliance by the okay.
Much.
Item 9.
This is a 483 BNSS application. This is petitioner was arrested on 18/10/2023 under section 22C of the NDPS Act. And there is already your lordship charge sheeted case. Charges have been framed in this matter. And there are challenges on two grounds, your lordship. First is with regard to long inculcation and second with regard to notice under section 50 grounds have not been. These are.
Have you annexed this one?
Yes.
Notice is annexed?
Yes, yes.
In which page?
That your lordship will find at page 40. Annexure 5, page 4.
Only notice you have annexed, arrest memo?
Arrest memo from the annex. Arrest memo from the annex. Forwarding is there.
Forwarding
Arrest memo. Memo of arrest.
In forwarding to, there will be ground of arrest, sufficient ground of arrest.
Yes.
You want
Memo of
arrest
arrest,
memo,
memo
arrest
of
memo.
arrest not been annexed.
Is required memo of arrest. Arrest memo.
Records.
Otherwise, we have to call for it.
In that case, your lordship call for the record. In that case, after the vacation can be taken up.
Second copy of the record along with the case diary be called for. This 23
I don't know. Yet a 9 some
24 for
lordship. Much appreciated.
Item 11.
That is about.
yes.
This case is about peculiar. Just before I take you to the FIR, what is the petition before lordship is the petition number 1. He is the secretary of Assam Aid India, and the petition number 2 is the president. It's basically a NGO dealing with the field of skill and livelihood of development of women in Assam. It was started in 2003. So what had happened, I had opened an account with Ujjibon Small Finance Bank in May 2024. Thereafter, the account was not active, not even activated.
The informant operate account.
It was in the name of the NGO. NGO. And what had happened, Lordship will just come to page 19 first, Annexure 3. On 7th of June, I received a phone call from the bank that certain amount was transacted through my account. Although the account was not even activated. I lodged a complaint thereafter, on 12/6/2020 with the bank. Now, Lordship, on the next page, 13/6, I lodged an FIR with the officer in charge cyber cell regarding the transaction. There was no residue in the account, but the only thing, the amount was transacted through the account. Now, Lordship, thereafter, at page 2022, Annexure 5, I lodged a formal complaint with the ombudsman, banking ombudsman. Now, quite recently, I received a notice under section 41, which your Lordship will find at page 11 and 12. Directing to appear, on 4/4/2025, before the police station sector at Noida, and the FIR your Lordship will find at page 13, and the contents your Lordship will find at page 16. Same thing, here is a person, through whose account, certain amount was transacted. He lost an FIR, page 16, to the SHO cybercrime so-and-so. With due respect, I want to state that myself, Soumyakanto Pusti, son of so-and-so, came across an online fraud transaction from my account of ICICI mobile banking with account number so-and-so. There is a transaction commenced on 7th of June, same date, 2024, with a total amount of 99,50,000 rupees through ICICI Bank via an OD account generated number so-and-so. It was happened that an amount of 10 lakhs credited through Insta loan, and then from saving account, the loan has been deducted through unauthorized transaction. The incident happened on 7th of June, 11:52 AM. I got a call from the FedEx saying that your Aadhaar card was detected with the suspicious activity, where some parcel sent to Iran using your ID, where there is an MDMA. We had blocked this shipment with a complaint filed to Mumbai NCB department, where you have to get yourself verified with your account, having no such illegal payments received from the suspicious account. So we will connect with a call from Mumbai's NCB, and then you will go do the verification process. After this, the next call received, and the person connected shared some ID with police at Mumbai Cyber Cell, named Pradeep Sawan. Then he verified me okay over call and checked my statement. Post my call, when I discussed with my friend, it was suspicious. Then I called the bank and blocked the account and debit card. At night, when I checked my mail, there is an Insta loan of rupees 10 lakhs, and then asked the ICICI Bank to check, then came to know that there is some unauthorized transaction made of 99,000, 5,000 INR through OD account. I request your support to register a case and support the stopping so-and-so. We are not named. The only thing, I have been asked to appear before the cyber cell department, and 41 notices have been issued to the president secretary, Here, I am a victim itself, because my account was not even operated, it was not even activated. Certain transactions were made. I lost complaints. My FIR is pending here. The only thing, since the Lordship, there is a judgment of the Honorable Apex Court, this is priya indurious, in case, even if it is, the case is registered in some other state, then the Honorable Court has the power to grant interim bail. I'll be appearing, because there is nothing, no amount was kept in the account. Certain amount came and it was routed through the my bank account.
For your bank account.
Through my bank account. And in fact, when the account was not even activated. This is basically the case, I'll just rely on this, Lordship. Perhaps if your lordship kindly comes to paragraph 30. Mark it, my lord. 30.1, whether the power of the High Court or the Court of Sessions or grant anticipatory bail under section 438 CRPC could be accessed with respect to an FIR registered outside the territorial jurisdiction of the High Court. Here, my lord, in this case, my lord, the FIR was lodged in Rajasthan. The Sessions Court in, my lord, Bangalore, my lord, allowed the anticipatory bail. And in fact, if your lordship kindly comes to '94, my lord, 93, my lord, sorry, 93, paragraph 93. Only thing, my lord, the Honorable Apex Court held that, my lord, it has to be for a limited period, enabling me to appear before the concerned IO, my lord, and thereafter, if required, my lord, to approach the appropriate jurisdiction. In view of what we have discussed above, we are of the view that considering the constitutional imperative of protecting the citizen's right to life, personal liberty, and dignity, the High Court or the Court of Sessions could grant limited anticipatory bail in the form of an interim protection under section 438 CRPC in the interest of justice with respect to an FIR registered outside the territorial jurisdiction of the state court and subject to the following conditions. Prior to passing of an order of limited anticipatory bail, the investigation officer and the public prosecutor who was seized of the FIR shall be issued notice on the first day of the hearing through the court in an appropriate case would have discretion to grant interim anticipatory bail. The order of grant of limited anticipatory bail must record reasons as to why the applicant apprehends an interstate arrest and the impact of such grant of limited anticipatory bail or interim protection as the case may be on the status of the investigation. The jurisdiction in which the cognizance of the offence has been taken does not exclude the said offence from the scope of anticipatory by way of the state amendments of section 438. My lord, now paragraph 94. It would be impossible to fully account for an exigent circumstance in which an order of extraterritorial anticipatory bail may be imminently essential to safeguard the fundamental rights of the applicant. We reiterate that such power to grant extraterritorial anticipatory bail should be accessed in exceptional and compelling circumstances, only which means that denying transit anticipatory bail or interim protection to enable the applicant to make an application under section 438 before a court of competent jurisdiction would cause irremediable and irreversible prejudice to the applicant. The court, while considering such an application for extraterritorial anticipatory bail in case it deems fit, may grant interim protection instead of a fixed period and direct the applicant to make an application before the court of competent jurisdiction. Now,
Where are the notices you have received?
That is your lordship will find a page. No, we sought time at a page 11 and 12. The fact remains there is nothing. We are not naming the FIR. My lord, certain whatever happened to me, my lord, it happened to the other person in the informant as well. My lord. 11 is the petitioner number 1, my lord, and the page 12 is the petitioner number 2. In fact, they are in Delhi, my lord. So they'll be leaving for Delhi today itself. Well, I'll appear before, but if required, my lord, I'll seek into regular bail in the appropriate forum, my lord. Allegations are 419, 420, and 66D of the Information Technology Act.
Yes, Kusan.
Yes, he has written intimated to bank lordship 12/6/24. His account is not operating. And FI was FI 7/6.
Next piece, please.
FI was lost down.
13/6, 24. We intimated the bank on 12/6, 24. The FIR was on 13/6/24. And below ombudsman, your lordship will find (19/7/2024). Last page 26.
Only thing is some transaction was through his account. Some transaction was made through his account as per. But how can it be possible without?
That is why we approach the authorities. The cyber cell is looking into it. The ombudsman is looking into it.
It's purely a cyber crime.
I'm just trying to cooperate.
I call for a case there.
Is there here not with us?
Delhi.
lying in the Delhi.
So.
The lordship will give me 15 days, my lord. Within 15 days, I'll appear, my lord. Let them record my statement, whatever is with us, my lord, we will produce it.
Okay, I'll pass the order. Just a second, Mr. Day. You received the notice when? On
I'll just.
in March.
No, in fact, my lord, just a few days back, my lord, I sought time thereafter, my lord. 22/3, my lord. My lord, that was issued on 23, my lord. I received it recently. It was fixed on 4/4. My lord, I sought time. I was granted, my lord. In fact, today is the date fixed, my lord.
Otherwise, notice issued on 20
22/3/2025.
for your
Appearance on 4/4.
4/4.
Or my lord, I mailed them, my lord. The next date was given 10/4. So today is the date for the appearance.
I think 12.
The petitioner, he's a owner of the vehicle, and his vehicle has been used by his driver and some persons to carrying transportation of cattle. FIR is my lord page 9, my lord. And Bhanakolar is my page 13. That's page 13.
5 couples in a Bolero vehicle.
Yes, Bolero vehicle. I am the owner of the vehicle. After that, it is my lord, now police has searching me, my lord. I found the vehicle and I.
So without your permission, how can?
No, my driver has taken the vehicle. I have a driver. My driver has taken the vehicle. I have a Bolero vehicle. It is a use for.
Vehicles were in a view to transport where?
Transport.
It is allegation is there, my lord. But they found public found that a Bolero pickup was standing on the road with 5 tons of cows. When they subjected it, then the people approached them, and then the 3 persons fled away by leaving the vehicle and cow. They informed the police. Police come and police recovered those vehicles along with the cows, my lord. So I am the owner of this vehicle.
Without the
So,
knowledge of him, the owner of the vehicle.
my driver is there. My driver is involved, maybe. I have no. Let them city call in the I will protect her because my vehicle is also going to be damaged. I will take Zimba of the. I am the registered owner.
Have you filed any JIMA petition?
No, because I police try to work searching me, my lord. I place you also can place 15 RC. I am the recorded owner of that vehicle, my lord.
Mr. Jadami, the land council for a petition. Morning. And also heard Mr. DP Gusami. So and so, this and so and so. It is submitted with Mr. Ahmed that the petitioner is the owner of the vehicle and he is no way connected in the office. The vehicle was used by his driver and he was not aware about carrying of any cattle as well as in the FIR. However, he is ready and willing to go it and deal. Okay, you'll be under interim protection. Yes, when it can be called.
8 of May.
Hello, let's. Wait, Mr. Doctor.
For it to be in a structure. Actually, parent the FIR lordship page 9 lordship.
Page 9.
Page 9 lordship.
Yes. So you are the company head or what?
Lordship,
The said, you are the,
I was
You were the
not engaged
manager,
as
huh?
an employee, Lordship. I was engaged in employee, Lordship.
one of the employee of the said
Lordship,
company.
Lordship. Lordship, kindly share his Lordship one authorized letter, Lordship, page 18, Lordship,
Page?
18, Lordship.
Ah,
This is the authorized letter, Lordship. Only authorized me, Lordship, to conduct Lordship office industry, professional training, microfinance, social activities, and sign documents as necessary, Lordship. No mention for any collection of money, Lordship. I will cooperate, Lordship.
Paper case day, Lordship.
so where is the, where you are authorized, your good name, your petitioner's name is
Lordship,
Rashidul Rahman.
Rashidul Rahman,
Rashidul.
Lordship. And I was Lordship, for the company.
So
Lordship,
you were authorized to conduct, so indeed in your period or your tenure when you were looking after the company,
only
that
for
that fraud was committed.
Only for 26/1/2025, Lordship. Thereafter, Lordship, I met an accident, bike accident, Lordship. Thereafter, I was admitted to the Dhubri Medical College, Lordship.
26/1.
26/1/2025.
So in that, during that period you were there. So
But
this
but
petition is not for,
this informant joined this company, Lordship, on 8/2, Lordship, February, Lordship, 8, Lordship. FIR was lodged on 23/2, and Lordship, that on 8/2/2025, I have taken membership of the said.
so where is your document that you have left the company on 26/1? Do you have annexed any?
I have mentioned, Lordship.
No, mentioning will be different otherwise.
I have
That he left the
medical
company.
documents is there, Lordship.
Huh?
The medical documents is there, Lordship. I have admitted, Lordship.
There was simple X-ray, abrasion was there, nothing was there.
They are depriving and
Abrasion on the right leg, abrasion on the left elbow, and the one X-ray was advised to you. That apart, discharge is there, no other document. Is that 26/1, since 26, you are not in a position to work in the company. Is medically is not at all sufficient because it is a simple document. You will most probably not an accident. You may face an accident. It does not matter. The question is that the injury which is we have submitted is these are the simple injuries. Some you were advised for X-ray. Sorry, that is it. So you have left the company on 26/1. It's not here. No document is here. Otherwise, maybe yes, you may leave the company, but whether these things will happen at the time of your tenure, we are not in a position to say that because the document is not there. So we are calling for a case diary. Otherwise, call for a case diary. Yes, when it can be called.
29th of April, Lordship. 24, Lordship. Dhubri ko nahi kono bondho take the 28 of April.
14.
May I please your lordship.
Yes.
Well, in this case, my lord, and my lord will find that the complainant, my lord, complainant has filed this FIR against his own children, my lord. That is the accused number 1, 2, and 3. Accused number 1 is a married daughter, and 2 and 3 is a college-going sons. And 5 and 6 are the father-in-law and mother-in-law, and rest are, my lord, brother-in-law and sister-in-law. And what happened in this case is this, my lord. So when the complainant has married the daughter of the accused number 3 and 4, my lord, marriage was taken place. They started living together, my lord, and out of their wedlock, my lord, accused number 3, 4, 1, 2, and 3 were born to them, my lord. Thereafter, my lord, his wife expired. And after the death of his wife, he came to his father-in-law's house as a Ghorjuai, my lord, and started living there. And the father-in-law and mother-in-law arranged a plot of land, my lord. in the name of the son-in-law. And my lord, boundaries were given, 2 houses were constructed, and then my lord, they were shifted to that plot of land. And they started living there along with the children, my lord. Then what happened, my lord? This complainant, my lord, leaving the children, went away and married a married woman, my lord, having a child. So regarding this, my lord, there was some dispute was taken place between the father and the children. And then ultimately he threatened that we would give a lesson to you. Then one fine morning, my lord, what happened? My lord, we do not know how it was happened, my lord. His mutation was cancelled on 6th of, my lord, March, 6th of March of this year. And on 7th, my lord, mutation was restored to him. Then subsequently, my lord, he filed an application to the ADC concerned, my lord, that his mutation was cancelled and subsequently restored, and at the behest of the accused persons, my lord, showing him as a dead person, my lord. That was basically that was the allegation. Then, my lord, a notice was served upon us, my lord, by the ADC, my lord. We went there, my lord. Then Mondal was called, Gaubura was called, then the doctor was called, and Dr. Gaubura and all everything, my lord, they have said, my lord, we have not issued any certificate like this, my lord. And we have also said that it was done by him and it was rectified by him, and he files this false allegation, my lord, against the children and the in-laws, my lord, just to give a harassment, because he has already married a married woman, my lord. Then, my lord, thereafter, my lord, he lost this FIR, my lord, again. And the FIR, my lord, will find at page, my lord, 13. Page 13 and page 14, my lord, will find accused number 1, 2, 3, my lord, his own children. 4, 5, my lord, his father-in-law and mother-in-law. And 6 to my lord, 10, my lord, they are the brother-in-law and the sister-in-law. So, my lord, at this stage, my lord, what I pray before your lordship is, my lord, then, my lord, let the city call for, my lord, and in the meantime, your lordship will kindly protect us, my lord.
The forging document, the complainant dates are provided to the couple of the firstly muted the land. So we have the documentary. Okay, we need the documentary. Okay, is there is required?
If necessary, my lord, for his FSL report may be called for.
Reported.
Everything is done by him. Everything is done by him, and my lord, just wrote to us, my lord, this FIR has been lost.
MS Council Modification. C. Chaudhary, Detention. Also for the petition, and also heard Mr. DP Kusan, so as an application section, so and so, initial with so and so. Chaudhary report, senior advocate, assisted by your Mr.
T.L. Chaudhary.
T.L. Chaudhary.
T.R. Chaudhary. और बाकी कुछ शामिल है इसमें application section so and so, connection with so and so. It is submitted by Mr. Chaudhary that all the accused petitioners are the family members of the informant. Petition number 1, 2, and 3 are the children. 4 and 5 are the mother-in-law, but in-laws of the informant, and the rest petitioners are the brother-in-law and sister-in-law. Present petitioner had lost the FIR only to harass the present petitioners after he married a woman. After marrying another lady, after his marriage with another married woman, on married woman, post. He fraudulently, again. He is behind the anti-crime of creating forged death certificate, etc. However, and the filed lodged a false complaint against the present petitioners. However, they are all ready and willing to cooperate the IO. in further investigation of this case, if they are contributed some interpretation. Okay, you'll be under interpretation. Appear before the IO within 7 days, cooperating and if. Yes, when it can be called for?
8 of
8/5.
8 of May. Okay.
8/5.
Actually,
The charge. According we find an affidavit, my lord, the record also record has. Charge, it has come in the record also, my lord. So charge was framed on 1/3/25. And High Court order was 18/12/24. Paisa na gitu itu.
Charge evidence of those areas.
Okay. Your lordship got it now. So the order dated 18/12, my lord. In the affidavit, this order of coordinate bench order, your lordship kindly see, my lord, page 36, my lord. Page 36. It is able in additional affidavit. Your lordship got it now. Order dated 18/12. Bottom. Heard so and so, my lord. Also heard the date 22/1/25 is fixed for consideration of charge by the trial court. Therefore, this matter be listed after consideration of charge by the trial court. The petitioner file a copy of that order after charge is framed on that day. After filing of the said order, this matter may be listed again. According to my lord, we file according as per order, we have filed copy of the charge also. Charge was framed. Next page, my lord, page 38. Your lordship, page 38. 1/3/25. That's fair, my lord. Now, my lord, my case is, my lord, I take to your lordships to just, my lord, one page that your lordship will make, my page 26 of the bail petition, my lord. Charge sheet also. Just, my lord, your lordship will. Page 26. From bottom, my lord, about 10-15 line above, my lord, I am taking. At the later stage of investigation, my lord. Page 30, 26. Your lordship, at the later stage of investigation, statement of Gaupoda and 2 local witnesses have been recorded, and it has come to the light that there was land dispute between the deceased and Farmal Ali, Islam Ali, and Mainul Ali. Islam Ali is before lordship, item number that first, this present petition is Islam Ali, my. So, in between deceased and Farmal Ali, Islam Ali, and Mainul Ali. In this connection, titles say case number so and so is under trial before the Honorable Court. During investigation, it is also found that FIR name accused Akhtar Hussain, item number next item, Akhtar Hussain. Chintu Ali, who stabbed the deceased, is the son of the Islam Ali. He is my son. During investigation, it has come to the light that Islam Ali, Farman Ali, and Mainul made conspiracy to kill the deceased and abated and aided Muhammad Akhtar Hussain, Chintu, and another Chintu to kill the deceased. Now this Farman Ali and Mainul already got bail.
Is order, sir.
Order is. Equal to the same. Mainul and Farman Ali. So main what are my lord against these 3 persons conspiracy part and 2 persons with that my lord item number next item, they have according to them they have stabbed that here my lord as per in conspiracy with that each other my lord. So I am my lord at this stage my lord your lordship so far the present petitioner is concerned he is 42 days my lord. 242 days as on today my lord. Arrested on 11/8/24. 11/8/24. And next item is, my lord, in 200, 2% 300, 226 days, my lord. Next item. Arrest, date of arrest is also same date, my lord, but it is, or 10-4. Yes, my 10-4-24, date of arrest, my lord. So for next item is concerned, 2 persons are here, 1 person, my lord. So my humble submission at this stage, my lord, already charge sheet frame, charge is also, charge is also frame, my lord. Yes, this is further custody, my lord, let him get some chance to, my lord, that defend his case, my lord. And since 2 already co-accused, already granted bail, my lord, on the same footing, my lord. Same affair name, same my lord, same that. You know, this is the code, this is the
By this
two orders, my lord. One order given by your lordship, other is by another bench. My humble prayer is that, my lord, your lordship may consider, my lord, because the length of the detention. At this stage, I am not in merit, my lord. Whatever is done, my lord, let them face the consequence.
Bail application number 593 also same after same.
Same, my lord, same. One is Farmanadi, one is Manul Haq.
How many witnesses as per his?
No, like 21 PWs, man. Not a
How
single.
many? Four.
Pardon?
Not 8 exam.
Not even single witness exam.
It was fixed for evidence on my charges were framed on my lord 13/3/25 this March, my lord. 13/3. No.
Asil, no?
Asil. And it was charged, and next, my lord, for evidence 10/4/25.
It's sufficient.
So I am only matter of length of detention, matter of further custody of this stage.
Where from this one is quoted lining? If it is out of same affair. This is
Yes,
this is
Nalbari 220.
No, but
Nalbari PS
Yes.
228. This is also same Nalbari PS 228. No, the order is also not Nalbari PS 228.
Yes, sir. Order is of Nalbari PS2. Because from the my lord, what has been transpired in the record, my lord. Let's make kindly go through the
As per
record.
you, third one frame.
First frame
1-3.
Charge framed on, my lord, yes.
1 to the page 38.
13/3
1-3. 1-3-25.
1/3 in the March, man. Therefore 10/4 is for evidence, my lord. 10/4, my lord.
Today.
10, so it's today, my lord. It is not there, man.
And 21 PW.
Lord,
Maybe out of some
Probably some.
someone had submitted, I think.
Yes, my lord. May I just check the record once more? Yes, that is just one date, my lord. Again, yet charge framing it.
You tell me this is copy.
This is
Okay.
First date, my lord, it is on 1/3/25 charges, and neither it is signed on, my lord, 13/3. That is one. That is. That's
That we have annexed.
Yes, any other submission?
Yes, sir. Regarding the merit of the case, my lord. The lordship is my learned senior friend has read out, my lord, that during the investigation, my lord, it has been found that Akhtar Hussain, Chintu Ali, Harman Ali, and another person conspired to stab the victim, my lord. Thereafter, my lord, fortunately, I'm not going with him because he already granted bail, my lord, for reasons, my lord. Now, my lord, regarding the parity part, my lord, Islam Ali, my lord, perhaps will not be at par with the other accused, my lord. He is the father of the, my lord, the accused, my lord, Sintu Ali, my lord. And other two petitioners are those, my lord, who actually stabbed the victim, my lord. So they are, in my humble submission, their status is not at par with the other accused person, my lord. Because they are the person who stabbed it, my lord. It has
Item number,
item number 15 is the my lord, father of Chintu Ali, my lord, who is prayed for in item number 16. Item
item number 15 is Islam Ali.
or Islam Ali, my lord. He is the father, my lord,
Chintu.
of Chintu, my lord.
And the main stabbing part is Chintu.
Main Chintu and other person who are in the bike, my lord. Two petitioners are there, my lord. Both are Chintu, my lord. One is
son of this father.
one is the son of one is Islam Ali's son, another is another son, my lord.
So the petition number 16 is for Akhtar Hussain, alias Chintu.
Chintu, and
He is
another
the
was
son of so and so.
son. So they are the
And
main
another who
assaultant.
is another. Another is also Chintu.
Another is also Chintu, my lord. Though both of them came in a bike, my lord.
They stabbed mainly.
Yes, they stepped, man, as per and they stepped, and he is the Islam Ali is the father, my lord, of the Chintu, my lord. So and
Regarding the conspiracy part,
yes, they
Islam Ali
conspiracy.
was-
Yes, so my lord, so there is at par, my lord. They may not be at par, my lord, as per my humble submission, because their status is different, my lord. And in martial lawship, she has to see the what is the role attributed, my lord, in a trial, in a criminal trial. Your lordship knows it better, my lord. So at this stage, I am objecting to their bail because the investigation reveals that their rivalry between their brothers and sisters, their rivalry, my lord, regarding a land dispute, my lord. And there is a status suit pending between themselves, and they are pressurizing. Then from the record, your lordship will find, my lord, they are pressurizing the victim, my lord, to withdraw that case also, my lord. And so, my lord, they conspired to kill this person, my lord. So it's a heinous crime, my lord, a pre-planned murder, my lord. So at this stage, my lord, may not be released on bail.
The question is that suppose Chintu Ali, that is the petitioners for in item number 16, there are two Chintu Ali who
Chintu Ali.
committed the murder,
Yeah.
and the others are in conspiracy.
Others,
But one of the conspirator has already been granted bail.
one other, yes.
Two already got.
Uh, That is one aspect.
Yes, that is one aspect. And he's the one is the son, my lord. He is the main part, my lord. Because
That Chintu.
yes, my lord.
16, item 16.
16, my lord. Because another person is because why I'm saying so, my lord, because if your lordship will find Akhtar Hussain is a son of Islamuddin, and another Chintu Ali who is in the bike, man. They are two assailants, my lord. And Islam Ali is their father, my lord. So, my lord, they are not the even though they are the part of conspiracy, my lord, their role is different, my lord. Because they are the person who actually my lord, I am not saying the benefited. They are the actual person who is into the crime, my lord. Because father and son, my lord, is the person's, my lord. So their role is different, my lord. And there is also rivalry between them. So they conspired to kill the victim, my lord. So now charges are framed, my lord. So let the trial be go as per, my lord. At this stage may not be released, my lord.
Then Mr. A.M. Houses for the petition, and also heard Mr. Appidusan. It is submitted by Mr. Richard Chaudhary that pursuant to order. Question to order date 27/3/2025. Passed in B number 3865/2025. Present petition for bail has been filed. Wherein the petitioners were asked to file the petition only after the filing of charges. In the present case.
আচ্ছা ফরমাট আছে
দুইজন আছে এখন।
27 now. 18, 12, I think. 18, 12, 20. Okay, number to go 3864. 3864 and ordered it 18/12/2024. Ordered it 1 I don't ask it for evidence. Mr. Chaudhary, for the subject that from the project itself, it is seen that the present petitioner along with 2 others were stated to be the conspirator who had conspiracy to kill the deceased, but they did not play any active part in commission of crime. However, the petitioner is in custody since last 242 days, as he got arrested in connection with this case on 11/8/2024. Case has already been accordingly. There is no chance of any hampering or tampering with the further evidence of the case. According to some, the local person, he will appear before the learned trial would be fixed by further ground of right to court law. This may be considered same footing and on the ground of verity. In this report that the charge it and other in the present accused petitioner is the father of one Chintu one who actually stabbed the deceased under the conspiracy of the present petitioner along with some others. However, he admitted that the 2 out of 2 conspirators have already granted the bail by this court, which is an admitted petition. But considering the matters in the case record, he raised objection and submitted that the cold-blooded murder and hence the petty prayer for petitioners may be rejected. That submitted that the dispute, original dispute, it was of land dispute. However, out of that land dispute, the present petitioner along with the others had conspired and committed the murder of considering this submission made by learned also considering the ground of parity, it has been ground of parity as the other conspirator, other accused persons who were also alleged to be conspirator of the crime had already granted the bail. Considering the case of the present petition, and ground of parity. Number 16. Mr. Same out of same case reference, so and so. It is submitted by Mr. Chaudhary, did not counsel for the petition. That the therefore it is present for evidence of the petition. And from the FI itself, it is seen that the these petitioners are not involved in any conspiracy or of commission of murder. However, they are behind the bar since last 2016. This has already been framed against. Accordingly, Mr. Chaudhary submitted that petitioners may fail. And being a permanent resident of their address locality, there is no scope of absconding. They will regularly appear and every date. Some committed in history. The present petitions are the actual executor of the time of the marriage. And they are the person who stabbed the deceased and committed the murder. The deceased was brutally murdered by these two petitions. Accordingly, he raised an objection. This is not at all applicable to allow the present to it was support in the case that find it is to allow the government to petition states and the prayer for these two petitions are it would be difficult to avoid the first submission was listened as per order dated so. The 15 is allowed, 16 is rejected.
15 rejected.
15
At this stage, man. Some clue your lordship may give, so that at this stage, obliged to lordship.
At this stage.
Obliged.
Regular bail application, my lord, in connection with an NDPS case. And here, my lord, the petitioner is banned for 2 years, 4 days, and 1 day. 2 years, 4 months, and 1 day, my lord, as in today.
2 years,
2 years, 4 months,
4 months.
and 1 day. As in today, my lord. And total 6 listed witnesses are there, and out of 6.
6 witnesses.
6. Out of 6, only 3 have been examined, as per my record, my lord. Right. And the PW1 and 2, my lord. PW1 and 3, they are the independent witnesses, and they have stated that they did not see the petitioner present in the vehicle, my lord. The petitioner, as per the FIR, my lord,
Said that PW1 and PW3 did not.
they could not recognize the petitioner, my lord. And my lord, here the allegation is, my lord, 2 vehicles were intercepted by the Khotkhoti police station on 8th of December 2022, my lord. 2 vehicles were coming from Manipur and Nagaland, having the registration mark of Manipur and Nagaland. And the present petitioner, he was the helper of one of the vehicle, which was coming from Manipur side, my lord, having the registration mark of Manipur. Now, total 3 persons who were arrested and forwarded to judicial custody, including myself, my lord. And here, out of the 6 witnesses, my lord, 3 have been examined. And now my learned PP, my lord, yes, my lord, informed me that total 4 have been examined as on today, my lord. So out of the 3 witnesses that the record I am having, my lord, PW1, my lord, your lordship will find his statement for a moment, my lord. I am coming to his statement, my lord. Lordship, page number 32, my lord. Page number 32, PW1, my lord, in his cross-examination, he stated that I have not seen the page number 33, my lord.
I have not seen the accused person in the truck. As such, I am not able to recognize the accused person today. I had not gone to NS 39 near SBI Kotkoti branch. I am a member of BDP. I often assist the police in their work. This is PW1, my lord. Now PW2, my lord, he is the informant. He is the police officer, my lord. And PW3, my lord, your lordship will find page number 43. And his cross part is page number 44. Here he stated that I do not recognize the accused person present in the court today. I had not seen the scene who were in the truck when the truck was detained. Now, my lord, only submission here is that the petitioner only, my lord, the length of detention, my lord. The petitioner was forwarded to judicial custody on 9th of December 2022. Arrested on 8th of December and forwarded on 9th of December. As on today, my lord, 2 years, 4 months and 1 day. My lord, earlier, my lord, this court in one of the case, my lord, relying on the decision of the Honorable Supreme Court, my lord, granted bail to one of the accused in to the accused in NDPS cases, my lord, wherein the accused was, my lord, behind the bar for, my lord, 2 years, 5 months. Relying on the decision of the Honorable Supreme Court, my lord, in Ravi Prakash case, my lord, lordship will find in the judgment the last page, my lord, bold portion. In the Eastern case too, it cannot be that the trial has not been procrastinated. 1 out of 13 witnesses has been examined. The petitioner is behind the bar for 2 years, 5 months. Now, relying on the decision of the Honorable Supreme Court, my lord, in the next para 8, my lord, Ravi Prakash case, my lord, the Honorable this court, my lord, granted bail, my lord. So I'm also, my lord, seeking for a similar consideration in my case, my lord.
Yes, ma'am. Here the petitioner is, my lord. He was found in conscious possession of the, my lord, one part is, my lord, heroin, and another part, my lord, 30,000 Yava tablets, my lord. And your lordship will find, my lord, he is very much aware of the contraband present, my lord, because he is bringing it in the form of a secret chamber in his truck, my lord. So after breaking open, my lord, it was found 55 numbers of sub cases where there is heroin, and another, my lord, another chamber was broken from where Yava tablets were found. And after investigation, the search sheet filed, and altogether 4 witnesses examined, and from lordship updated witnesses has come, my lord. Lordship PW4 has also, my lord, supported the case of the prosecution side, my lord. So, my lord, and there is no delay as such, my lord, as my learned friend has submitted the decision that Ravi Prakash, my lord. The facts are not alike in this case, my lord. Because there the trial period is been observed, my lord, not likely to come. So here, my lord, your lordship will find out of 6 already 4 examined, my lord. So there is no such delay, and there is no violation of Article 21 at this stage by keeping them behind the bars, my lord. So here, my lord, rigors of 37 will apply since the commerce will continue,
Code
and the satisfaction of the court.
My lord,
It's must, my lord.
I'm not the driver of the vehicle, not even the owner of the vehicle also, my lord. I was shown as co-driver of the vehicle. In fact, my lord, I was the helper only, my lord, of the truck, my lord. I was engaged as a helper of the truck. So, my lord, even I did not have the knowledge what were the contents in the vehicle, my lord. So ultimately, the contents found by the police, my lord, from the vehicle, my lord, those contents were, my lord, not in my knowledge. Even the police also, my lord, have shown me as co-driver of the vehicle. Only co-driver means handyman, my lord. I'm not the driver of the vehicle, my lord. The contents were found from the, my lord, the chamber. My learned friend is submitting here. That chamber is, my lord, obviously, if it is if contents were in the chamber, my lord, then only the driver can, my lord, either the driver or the owner of the vehicle, they can only answer.
Cases which were already granted bail, suppose considering the long incarceration, in that case, you will see that there may be 8, 9, 10 witnesses, only one examined, 3 witnesses.
In that
But
case,
here
it is
the case
different.
a bit different because out of 6, 4 has already been examined. Cannot be said that it's a delay, you don't delay in the
Inordinate delay.
trial.
Otherwise, the petitioner's my lord, he is willing to participate in the trial, my lord. So, my lord, even after
He is from?
my lord from Manipur, my lord. Even after his release also, my lord, he can participate in the trial, my lord. He'll face the trial, my lord.
That is
Very,
okay.
very unlikely, my lord, from if it is my lord. Release at this stage, my lord.
Okay. we'll pass
My
it.
lord, may I seek some time, my lord, because I want to place one judgment of the Honorable Supreme Court, my lord. My learned senior, my lord, is helping me here, my lord. So only short time, my lord, may be granted, so that my lord, since my lord, the contents were not in my, because I was the only co-driver as shown by the police, my lord. In fact, I was the helper of the vehicle, my lord. The contents of the vehicles were not in my knowledge, my lord. So only on that point, my lord, I want to place one judgment, my lord.
Place the judgment, I'll pass the order.
Not today, my lord. My lord, I
We
will.
don't have any time.
My lord, only short date, my lord.
Short date means? What do you mean by short?
Tomorrow, my lord. Tomorrow, my lord.
We don't have any days. It will be after Bihu.
After Bihu, my lord. After
Yes,
either tomorrow at 2 o'clock or after Bihu, my lord.
No. Tomorrow, we don't have any day.
After
You're
Bihu,
not
my lord.
listing, that's what I'm saying.
No issue, my lord. After Bihu, my lord. Any date, my lord, as per convenience of the honorable court.
CD to racket over. After Bihu.
After Bihu. Oh, sure.
After Bihu, we do it. Huh? 30 will be too long for you or it will be okay? 30? 3030?
Okay, my lord. Okay.
In the meantime, lordship may call for the updated LC also, if any witnesses.
In the meantime, updated. Here, along with the present status of the case will do, I think.
Yes.
Present status of the case record. No, updated enough. Updated case record along with the present status of the call. Okay,
Alright.
we'll instigate on.
All right.
Please, lordship, my lord. The offence is under section 22C, my lord, commercial quantity, my lord. 200. And behind the bar, my lord, more than 110 days, my lord. Probably 111, 12 days, including today, my lord. Yeah, my lord, lordship may come to the FIR, my lord, in vernacular, my lord.
At which?
Page 14, my lord. .622 kg, my lord. The SPM PRX capsule and nitrozepam tablet 80 has been said to be recovered from my vehicle, my lord, while I'm proceeding to my lord, to Nikata, my lord, at about 1:30 a.m., my lord. So, my lord, only my humble submission before lordship, my lord. The while seizing the, my lord, this contraband, my lord, the substance, my lord, the procedure, my lord, prescribed under 52A is not followed, and my lord, the section 50, that my lord gazetted officer, they have said that the circle inspector was present, my lord. He is a gazetted officer, my lord. But he's while the invitation has been prepared, my lord, he is not signed, my lord, or he has been not shown as a that during that he was present, my lord. So if, my lord, that is so, my lord, the rigor of, my lord, section 37, my lord, 2 Roman 2, that stringent provision, my lord, there is a less possibility of conviction, my lord. That means I am not involved, my lord. And, my lord, second ground is that, my lord, if there is a possibility or, my lord, further commission of offense, my lord, that is there is no earlier punished, my lord, so that cannot be, my lord. There is no possibility at all, my lord. We cannot presume that one person will again commit, my lord, if there is a prior, my lord, criminal antecedent, my lord.
As
So,
per you, do you have, he has any criminal antecedent earlier?
No, my lord. So, my lord, considering all this, my lord, period of detention and the, my lord, though it is a commercial quantity, not that much huge quantity, my lord, consider the bail, my lord. I'll cooperate with the investigation, my lord. Because of that, my lord, section 52 and 50, my lord, that, my lord, that.
How can you say at this stage that 52A is not complied with?
My lord, lordship to come to
50
my
is okay, how 52A?
52, my lord, some procedure has to be, my lord, maintained, my lord, that is, they followed, my lord. But they have not.
Obviously, there are some procedure for.
Well, if it is city is there, my lord, whatever documents I got, my lord, from here, my lord, I don't find, my lord, but maybe, my lord, city the procedure, because while I applying the copies, my lord, what is required, there, what is document required to be supplied, they have supplied. But beyond that, if it is something against me in the city, I don't have, my lord, access in the city, my lord.
Basically, his in case is that there 50 at the time of search or whatever, or 52A is not complied with.
Lordship. Lordship, my first
Case is
submission.
not transited one, I think.
No, Lordship, my first submission is, Lordship, the matter is still under investigation and FSL report has not been received. Otherwise, Lordship, the seizure report, seizure, if Lordship kindly sees, all these articles have been recovered from his conscious possession from the vehicle, Lordship, he was driving. And section 50 does not come, Lordship, because section 50 relates to body search, Lordship. So that does not come. Regarding 52A, Lordship, compliance, satisfactory compliance is there. There's the certificate also, Lordship. Order is also there regarding sampling and application.
Certification is also there.
Everything is there, Lordship. In any case, Lordship, even if, Lordship, at this stage, Lordship, that may not be gone into, Lordship, because it is still under investigation, Lordship. At least the IO has to get the reasonable opportunity to investigate the case, Lordship. This is involves commercial quantity. He has to satisfy your Lordship 37. Regarding 37, he has to satisfy, Lordship. That is my humble submission. Otherwise, Lordship, I can provide the case diary also, Lordship.
Call for one upload case diary, my lord. Because if they are saying that report is not coming, it may not be that, my lord, that psychotropic substance, my lord.
Then we'll call for the
Otherwise, so, my lord, as per provision of law, 6 days, 60 days the initial period. Well, I'll remain for 10 to up till Bihu, my lord. Then we call for the report, my lord, FSL report.
180 days.
It is 180 days.
180 days. 180, sorry.
180. Let it be in the month of May, Lordship.
May will be too far.
Maybe first week of the May, my lord.
First week of May.
May, my lord.
5th of May, Lordship.
5th of May it can be called for. 5th of May will be how many days?
5th of May.
My lord, it will be another 1 month, my lord, 40
Near
days.
about 1 month.
140 days, probably.
Less than 1 month, near about 1 month. Okay, then let us call for the case updated. Is there we call for FSL report you need?
Yes, my lord, FSL
Because
report.
obviously, if it is not in a positive, then obviously there
That's a
will be no
different
case at all.
My lord.
Let us see, we'll call for the update.
My lord. My lord.
Office note. Where's on?
Detention deduce. Kapan itu time logo.
May I please, Your Lordship?
Lordship.
Regular application, my lord, 40 days behind the bar, my lord. 40 days behind the bar, my lord. POXO 8 is there, my lord.
POXO regarding service of notice also, Lordship, we have to take instruction.
Oh, he has already applied. Otherwise, you have received?
No, Lordship, CD has not been received.
43 days, my lord. As on today. POXO 8, my lord, 60 days mandatory.
Immediately on reopening, Lordship will produce the case diary from North Lakhimpur.
Till 60 days offense, I think.
So today is 40.
What
43.
is your submission? Any submission from your side? Pardon? No, that was called for. It has not been received. So do you have any instructions from your client? Do you want to submit anything? Huh? At this stage, nothing means? I couldn't follow you. You could say. Itu gimana kayak gini? Ma'am, You are Mr. Estrana, no? Estrana. So do you have any instructions? Because you are not the legal aid or amicus, that's why I'm asking. What is your instruction? Because we have not received the case there. On the other hand, he is submitting that the petitioner is behind the bar for 43 days. That's what I am asking. If you think that the CD should be there, then. Yeah, fine.
Lordship, let it be on the reopening day, Lordship. It will be around 50 to 53 days.
On the
Otherwise,
reopening date,
Lordship,
on the reopening date.
21 or 22.
Otherwise, FIR is there.
Yes, yes. Allegations
Yes,
is there,
allegation
Lordship.
is
Allegations there, Lordship. The victim girl is around
kindly
14
peruse the
years of
FIR,
age.
my lord.
Victim girl is around.
14 years of age, Lordship. Lordship,
Kindly
you
peruse
find
the
at the
FIR, my lord.
forwarding page 15.
Particular is on 13, my lord. FIR says that in drunken condition, he bite her girl, sick of the girl, my lord, and fled away. That is the allegation.
Lordship.
Mr.
M. Rahman, my lord. M. Rahman, Mohibur Rahman.
Part Mr. Mr. M. Rahman, the Lanet Mr. B. Sharma, the Lanet Edition PP. Estrana, appearing on behalf of the respondent. Submitted by Mr. Sharma, that CD is not. Rahman submitted in this record that petition is behind the bar for 3 days.
43 days.
43 days. And thus the I got sufficient opportunity to interview. But he submitted that case is registered on considering the matrix fire and other and the forwarding report petition the bail prayer for the present petitioner maybe. Then when his presence is required and Sharma, the learned edition submitted in this regard. The ingredients, the statement made in the FIR clearly establishes a case under section 8 of the that is not in a position to say the other on the merit of the case. And due to non-availability of the Rana, the learned appearance for the submitted that it may be called for. Then the and only considering the length of the interrogation. Where it is pending?
My lord.
It has to be satisfaction to his home.
Satisfaction to Chief Judicial Magistrate, not Lakhimpur, my lord. Forward there. Yes, forward there.
Forwarding is there.
Yes, my lord.
Let's say if it is in before special judge, because what is the procedure that after one remand is from this CGM and all?
Competent, maybe written as competent.
Huh?
Maybe written in competent court, my lord.
What do you say? Well, it is pending. If it is already gone to the special judge, then it will be special judge.
My lord, in a forwarding, it is seat CGM, my lord. Not such seated, so it may be in the CGM also. That is not known to me, my lord.
Because you don't have any prayer for alteration. That's why I'm asking. You just if case is already transfer innocent is not committal procedure. If transfer is there, if we need, if it is before the
Let me special POCSO matters.
special POCSO is why. Pepsi POCSO which country?
Not looking,
Lakhimpur, not Lakhimpur. Special just Lakhimpur, not Lakhimpur. Okay.
granted,
You're
madam.
granted.
Outline.
लंबाई हो सही आपको ठीक है तो
Please, your lordship.
Only for short submission. We have a meeting, in fact, one. We have a meeting, that's a short submission made.
Short submission, my lord, in a similar case, my lord, your lordship has already considered the bail and enlarged his, he arrested subsequent to me. I am 465 days behind the bar. And other section, your lordship has given indication, all this provision of law, which has not been followed, madam. Same case, madam.
No, other one was arrested on the basis of some CDR analysis, in fact.
Yes,
But your petitioner is also on CDR analysis, I don't think so.
but same person
What?
have arrested me.
No. On the basis of CDR analysis.
Yes, I was the occupant of the vehicle, my lord.
No. The other one, there was a submission that on the basis of some CDR analysis that he got arrested, which may not be.
Well,
that
my lord,
was a
whatever
submission.
might be, they have been implicated under 22C in all the persons. And 485 days, I am behind the bar. And out of 9, which is
No,
a
no,
2.
there may be some differences. You may be arrested on the basis of the statement of your co-accused.
Yes.
Other may be basis of the CDR analysis,
Yes.
CDR analysis. So your case falls under which category? I don't know.
Page 36, Lordship will kindly come to.
Case 36.
36.
Yes.
Down below, Lordship will find point number 1, Siabuddin.
Your
Yes.
petition is Siabuddin?
Yes.
Yes.
Inventory of sampling of the drugs.
He was
In which-
the owner of the drugs, and the drugs he, along with Abdul Manan and Mitaul Ahmed, took the drugs and they were supposed to deliver the same to Jahedul Jahed. So he is the main person, Lordship.
And the other one was in continuous touch with their partner.
Yes.
And the other pleas, do you have any other pleas?
Beg your pardon?
Any other pleas you have?
My lord, you have lordship reflected the judgments of apex court, my lord, regarding 47, 48, my lord, that has also not been
So
followed.
do you have annexed the 47, 48 here?
Which was not served, how can I have? In the, my lord, this charge sheet also, it is not mentioned.
No, you are shown it is here.
No, I was taken into custody from the place of occurrence. I was taken to police.
Where it is written in forwarding.
Forwarding is not, I have given, forwarding is there. Forwarding is dated page 20, my lord. Nothing is mentioned there. Page 20, nothing is mentioned. During the search, all these things.
One mention is there. One medical examination.
That is, that they
certificate,
do, my lord. Yes.
And number 2 arrest memo and number 3 notice.
The arrest memo is, nothing mentioned that. I have been communicated these grounds.
No, that's what I am asking. You would take the plea. That is okay. But the question you have annexed. Do you have annexed? You have not annexed.
I do not, I have not. He is not
Then you
given
can
to-
see the record if it is there or not, because he is also taking the same plea that it was not.
Can be has come. my lord.
If you have come with that plea, at least there should be something, no?
Yes. But that judgment, your lordship has very nicely reflected, the quoting the apex court judgment to
So that is now at present, these pleas are taken by most of the advocates in connection with some other cases. But the question is that we need that 1 day's notice.
Examine it, it is here.
You'll see to it here. His name is Mr. Sharma. He is Sahibuddin,
Yes, Sahibuddin.
alias Siabuddin. That was-
50
that was
notice is
submission.
there also.
Huh? 50 is
Section
there.
50 notice is there.
It is not, question is not supplied to you now. You have not collected that one. That is.
Had it been supplied, it could have-
Mr. Harry's submission to depot. A Sharma submission to depot. That from the charge sheet itself and from the other materials in the case record, it is seen that the present petitioner is the owner of the drugs and the drugs along with and the drugs were supposed to deliver to one of the co-accused, Jahidul Islam. And from the CDR analysis, it is found that the present accused petitioner was in frequent touch with the said co-accused, Jahidul Islam. Again, take a submission of a commercial quantity. Otherwise, you are innocent or no?
We are already innocent, my lord, till the time. And Procedural, my lord, till today, my lord, charge sheet was framed in 2024. Till today, my lord, only no other witnesses are coming up.
Sahibuddin, na?
Yes.
Admittedly, the grounds of arrest are not there.
Yes.
আগরটা আছে ওটা এটা নিশ্চয় more or less মিলাই দেব কারণ সিডি অ্যানালিসিস পরিমাণ না লাগে হি ইজ ইনোসেন্ট নো রিকভারি ব্লাড ডিলে আর হেটার সাবমিশন হি ইজ দি ওনার যেহেতু আমার শর্মার সাবমিশন দিছে so otherwise you are submitting that he is the in fact the owner of the drugs.
There are other materials. But question of detention of long detention, that is also to be considered, my lord.
Your
Besides the
petitioner
other
is
two,
behind the bar since when? How many, since when your petitioner is behind the bar?
since 11/12/23, 485 days, 86 days today. And witnesses are not turning up. Charge frame to the 24.
Same order হবে না। And after the bail, if bail is granted, suppose, if not, then it's okay. But if bail is granted, then you are from which place?
Local from Karimganj,
Very local.
very local. I undertake, my lord, any
Not from Manipur, Mizoram.
No. I'll undertake any surety, I'll attend regularly, my lord. Or it should be cancelled, my lord. And my father is.
Now, after cancelling, you will not be found, na? That's it.
I will be able.
Your
I
attendance,
my lord, I am a
proper
young
your
man of
attendance is
31 years.
very much, very,
I am
very proper.
young man of 31 years. I will never do.
That's why you will, young man, that is the other reason.
My lord,
Going to.
after young man,
abscond.
sometimes they fall into prey of something. They've done it if it is considered. My lord. Kindly, under any condition, my lord, if required by every 15 days, I will go to the police station.
Okay.
Also, kindly text of the bail matter.
Yes, Mr. Pathak.
Yes, agree.
Article 21, I cannot. Basically, matter of Article 20.
That's what actually in my chamber, I was talking by Kim. That there are some truthy matters are there. So if that can be taken up, because you may take some time.
That is definitely 21 that gets the precedence.
I have already heard
Yes.
Muzumdar, I have already
I
heard
guess.
your part. So I have already noted down all these parts. So remaining part will be from Mr. Pathak. Okay.
I'm sorry, my lord. I am sorry, my lord. I have for listing a urgent matter, my lord. On tomorrow, bail, my lord.
No, sorry. No listing. No list. Bill hearing এটা আছে, bill hearing করে দিও এটা। আর একটা one letter মধ্যে fix two. Itu করে দিব।
And after he said that he was engaged in some other.
He's not here now.
He's not here. But his associates said.
So equals to মাটি দেব, 1526 মাটি টাকা।
My lord, with respect to one item, my lord, minor modification of your lordship's order granting me bail. I is ready, my lord. If my lord desires to take it up, allow this to be taken up today or alternatively tomorrow, man.
I is here with us.
Yeah, it is not being filed, man.
Huh?
Well, it's being filed now.
Huh.
So why not, if not today, let it be taken up tomorrow as an item.
I don't know.
Huh? Tomorrow it may be taken up, my lord. I'll file it.
Tomorrow we are not listing, that's what I'm saying. There are some matters, we are leaving court a bit early because I have a flight also, so we don't have listing. Alteration only, modification is there.
Modification, instead of two sureties of one government surety has been insisted, my lord. So let it be one
it's
local
not-
surety and the bail amount may be increased, my lord.
Oh,
Bail
no, not possible. Two security, there are some reasons why two securities were there. It's some reason behind we are giving two security. There are some reasons. That's why it may not be altered also. Try to get one security, more security. Somehow.
Surety, my lord, we can, you know.
Somehow you try to collect because people are from,
they don't
I know the cases are very nature of case.
They don't belong
So
to-
yes, that is the reason. They don't belong to Assam. That is the only reason. That's why we are giving two securities. Somehow we need their attendance. Somehow we need their bond amount, but you know, I know the actual fact, what is going on. Bond amount, if I increase to 1 lakh and 2 lakh, even 2 lakhs also, your petitioner will give 2 or 3 lakhs to the bailer and he will abscond. That is what's going on. So we are on two security. That may not be converted.
It's as good as not getting bail, my lord.
Huh?
It will be denying bail, my lord.
No, there are some reasons. That's why.
My lord.
There are maybe some conditions
I
may be
can
there
appreciate.
which are not cannot be, but we have with some intention, some reasons we have given. Sorry. Okay.
22.
এগুলো কি মহিলা মহিলা বন্ধ দিচ্ছেন এক খাটান দিনের বন্ধ আছে they are so around the matter here.
May I please, one city was called for my lord.
Yes, yes, sir, seated, madam.
My lord, kindly, my lord, can copy of my lord, city may be called for. He is in jail also.
22.
Yes, madam.
Can copy of the case record along with the CDB for here's the report. এগুলো লিখবো না লাগে লিখে লিখো list.
It is in the
Yes,
court,
Goswami.
it is in the court of my lord, the additional session judge 1 Nuagaon, my lord. Now.
We'll
Box of
see,
case
we'll
number.
see courtroom, we'll see court. By the registry also it will be looked after. 21, 25 for you, okay? 25 for 25.
Apply.
23.
May it please, Lordship. Lordship, the petitioners are behind bars till today. It is 42 days they are behind bars.
Service, my lord, I don't think, my lord, did you have received, my lord, but regarding service, my lord, Nadia.
There is an office note says copy has been served, madam.
Office note?
Yes, madam. On 8/4 that office note is there.
Notice is served. It's a POXO.
Yes, madam, 12 is there, 60 days of it, POXO 12.
Your petition is behind the bar since when?
Since, madam, 26th of February till today, it is 42 days.
Immediately on 21st, can it be? 21st or 22nd. Amicus that I appoint for you, heard Mr. T.R. Sharma, the learned counsel for the petitioner, and also heard Mr. M.P. Goswami, the learned additional PP, appearing on behalf of said respondent. As per office note dated 20, as note dated 8/4/2025, the service is already completed on respond number 2.
May I pray for listing in the vacation bench?
Vacation bench is there. Is constituted. Not yet constituted. By
Then on
appoint
21st, madam.
MSP Agarwal, MS or Mr. MSP Agarwal. be appointed as an amicus. Rest you will do the needful. CD already received, no?
You already received, my lord.
CD is be retained till next date of listing. List accordingly. 21, I don't know, it may not be possible. 21, are you on the book? 22, 22nd. 22nd.
18 or something.
My lord, I have another one prayer, my lord. My lord, in the cost title, the name of the first petitioner, there is a mistake, my lord. I will file an IA in the meantime.
Sure.
Please. Okay.
24.
Please,
Yes.
Lordship, the petition,
CD we received?
Yes, that's.
Lordship, the offense, the statutory period for all the offences, Lordship, is 60 days. And the petitioner is behind the bar since 53 days, Lordship.
53 days.
behind the bar.
What is the position, Sharma?
That is the difficulty, Lordship. Some of the courts are yet to be arrested. And it was earlier rejected by the Lordship at stage
It was earlier rejected.
21. Yes.
Lordship has
Oh,
already
it's a
granted
fraud
bail
of
to
bank
private.
make accounts and all ATM card. But the case, nature of case, I can understand it's a very serious nature of case. But the question is that obviously 53 days has already been gone,
Lordship,
but
that is
within
the
7, 8
difficulty.
days, most probably probability is not there.
Judicial official state commission may be imposed actually.
You are MS?
S, yes, me.
Hard MS S, Yasmin, do you know my name? The learned counsel for the petitioner. And also heard Mr. B. Sharma, the learned additional PP, appearing on behalf of state respondent. This is an application in section so and so in connection with so and so. CD received. Where is received? It is submitted by MS Yasmin that the present petitioner is behind the bar since last 53 days, and hence, considering his length of detention, prayer for bail may be considered. However, the petitioner will appear before the investigating officer as and when his presence is required. Next para, Mr. Sharma, the learned petition PP submitted in this regard that the earlier bail petition for the present petitioner was rejected by order dated 24/3/2025. 24/3/2025, and considering the materials, incriminating materials against the present petitioner. However, he submitted that some of the co-accused persons are yet to be arrested in connection with this case, which may take some more time, and hence the probability of filing of the charge sheet within the statutory period cannot be expected at this stage. In view of this, without going into the detail of the merit of the case, only considering the length of detention of 53 days, the prayer for bail is hereby allowed, and accordingly it is provided for you. Okay, your bail.
Verified.
25 Lordship, the CD has been received, but the FSL report has not yet been received.
FSL report is not there.
Yes, and today's Lordship, to my calculation, 45 days. And the recovery is of 15.5 kg ganja, Lordship, from these two persons. So may I pray, Lordship, that the matter may be fixed on 21st April, Lordship. In the meantime, we'll send back the CD for FSL or whatever, Lordship.
Otherwise, it is an intermediate quantity.
2.5 kg of ganja, Lordship.
FSL is not there.
FSL is not received, Lordship.
Your petitioner is behind the bar since when?
From
On 22, Lordship, 22 February 2025, Lordship. And today is 48 days, Lordship. And nothing was recovered from the petition number.
48 days, it will cover 60, 21, it will cover.
Lordship,
20P subsection 2, Lordship.
21 will be?
Lordship, allegations under section 20.
No, 21 will be 62 days. No.
Yes, Lordship, on 21, Lordship, 60 days will be.
no, 58 days. No. It won't be, Lordship.
Lordship, on
No. Today is 46 days. Lordship.
People count lordship on 22nd February lordship. It is 48 days lordship.
47 days ago.
47 days.
47 days. Lordship. 58 days will be on 21st.
List on 21st. Petition CD received. And list on 21st for you, CD, those CD received, but the learned additional PP, they were directed to, you keep the retain the case diary, only call for the FSL report if any. And he's asked to call for the FSL report, oblique the status of the investigation from the IO council. CDB retained till next date of testing. List accordingly. Okay.
26.
26. Lordship, CD has not been received.
Look, on the last occasion, your lordship will kindly recall, this boy had just appeared for his higher secondary examination and just crossed 18. But we have taken a ground specifically in page 32, your lordship will find. All the offences are punishable by 3 years, except one section of the IT Act, which is first time offender is 5 years. Your lordship will find at page 32, the first line, the IO could satisfactorily explain for not serving the notice under section 35(3) of the BNSS, which is earlier under section 41A of the CRPC. This is a mandatory requirement, my lord. You cannot relax by saying that the IO has given an explanation. And for he is in custody, my lord, from 17/3/2025 for last 27 days. My lord, I pray, my lord, that further custodial detention may not be necessary so far the investigation of the case is concerned. Because if your lordship looks into the FIR at page 22, page 22, my lord, I am not named in the FIR. The prosecutrix or the victim, my lord, has shared her private pictures with her boyfriend. And that was long back, my lord. That was in 2017. Now, in 2025, probably due to the stale relationship with the boyfriend, my lord, the boyfriend had put those pictures in Telegram. Now, so far my involvement is concerned, my lord, my UPI ID was used to take money from the person who viewed the picture, 2,000 rupees or something like that. That is the allegation. So far, my lord, investigation is concerned, my lord, my mobile phone, everything has been seized, and I respectfully, your lordship will look at page 22 that it was with her boyfriend, my lord, Gautam Das. Gautam Das has also been arrested and in custody. Your lordship will find at page 22 the your lordship will find at page 22, I shared the photograph with Gautam Das residing in Kahilipara around the year 2017. She had shared her private pictures with Gautam Das, who had an affair at that particular point of time. And in the Telegram account, my lord, there are more than 2,000 participants. So, my lord, considering as a first-time offender with no criminal antecedent and considering his tender age, my lord, your lordship may consider his bail application. Your lordship will find his education testimonial at page 13. Ultimately, he has to face the trial or he can be a witness. Page 13, your lordship will see. I'll not name the institution, my lord. Page 13 and 14 are the credentials, and 15 is the credentials, 16. Just higher secondary pass and cross, my lord. And now the process for the next graduation process concerned. But since he is in custody for 27 days, one initially taken to police custody, interrogated, I respectfully pray, my lord, that further custodial detention will not be required. That is number one. Second, my lord, admittedly, section 41A notice has not been served. 41A of the earlier CRPC, and now it is 35(3) of the PNSS. And I'm willing to cooperate with the investigation, my lord.
Yesterday, Lordship had gone to the motion matter where CD was called for Lordship regarding the main accused Lordship, Gautam
Das.
It came up for motion yesterday, Lordship. CD was called for Lordship. Same FIR, Lordship.
Acha.
Anyway, Lordship, here Lordship will kindly come to page 24, Lordship.
24.
Yes, 24, Lordship. This is the forwarding, Lordship. Lordship will kindly see the grounds of arrest, point number 1. Grounds of arrest, point number 1, Lordship. Based on the victim's information, we collected bank records associated with the UPI ID, Manoj Biswas 1. So during the investigation, it is revealed that the said UPI ID was used by Mansab Biswas, who sold the nude photographs of girls, including the complainant, and received payment through same UPI ID. So Lordship will see nude photos of girls, including the complainant. That is to be noted, Lordship. Second point, Lordship will also see the accused uploaded and shared vulgar and nude photos of girls on Telegram group, causing harm to the victims and violating social norms. Second page, Lordship will kindly come. Page 25. Reasons for not applying the 35(3) notice has been given, Lordship, in this paragraph. That apart, Lordship, if Lordship kindly comes to page 31 for a moment. The bail rejection order by the learned court below. Page 31, Lordship, second paragraph. Just I'm reading the brief fact of the case is that the informant lodged an FIR stating that she came to know about circulation of a nude photos on Telegram group dated so-and-so from one individual, namely Jean. Upon receipt of the same information, she contacted Jean and collected 2 numbers of photos of her and learned that her private photos are circulated through a Telegram ID so-and-so. The complainant further added that she provided those photos to one Gautam Das of Pahilipara in the year 2017, hence this case. The case was registered under so-and-so. Next paragraph, Lordship. On perusal of the case diary, it appears that although accused Manoj Biswas, that is the petitioner, is not an FIR named person, he allegedly sold the nude photos of the girls, including the complainant, and received payments to UPI ID. The allegation against the accused is serious in nature. The accused has been intimated about his ground of arrest, though notice under so-and-so has not been given. So, in a nutshell, Lordship, without perusal of the case diary, Lordship, and without knowing the stage of investigation, Lordship, it will not be proper, Lordship, to release him on bail, Lordship. So, I am praying, Lordship, for holding of the case diary.
In other matters, when the case diary was 54? 23 for.
I'll give a short reply on it. So far, what is act is done, this act of voyeurism. Look at nude pictures of girls is voyeurism, I admit. Punishment is 3 years. Means it can extend to 3 years. Other section of the IT Act is also is 3 years. This page 24, the account. The unfortunate part was that this is the account of the father of the boy. The father was also called to the police station. He cooperated. He said that my son had used this UPI ID for his without my knowledge. So father was not arrested. The son was also cooperated with the investigation, giving all the statements that were required, because this Telegram admin was Jim. Telegram admin was Jim. And the girls have herself said that in 2017, I have shared this explicit photographs of my mind with Gautam Das, who is in custody. Well, it's my only respectful submission that considering the tender age of the boy and last 27 days is in custody, and I have showed your lordship the credentials of the boy. Now further custody and detention may not be necessary so far the investigation of the case is concerned. That's why I have paid for bail of this accused person considering the CD. If it was any other case, I would have patiently waited for another 12 days or 13 days for 2 weeks for the CD. But here your lordship knows the conditions in the jail. Every day the parents goes and meet the boy and he is not used to this type of. Everyone makes a mistake in life. But that mistake he has already committed and now in 27 days in custody. The rest will be, my lord, will be, if it is proved during the trial, he will face the consequences of the. That is with my utmost humility, I am praying that your lordship may consider, my lord.
Sure. I'll pass you.
Yes.
Yes.
Your lordship has fixed one matter at 2. Only a simple observation, my lord, is notices has to be go. Without notice, your lordship can't consider this application which I.
Item number?
31, my lord. My lord, your lordship's order is at, my lord, page 120.
But in item 31, my name has been shown. But perhaps I had appeared as a caveator in the main CRP.
Yeah.
So my
Oh,
lord,
your name has been shown here.
Caveat stands discharged. So my lord, my name may not be shown. Let notice go, my lord, to all the respondents.
We'll take justice steps also, my lord.
How many eligible respondents are there?
Yes, my lord.
How many respondents?
Yes, just a moment, man. 31. Total 31.
31 respondents.
Your lordship will also permit us to take justice service along with usual notices.
31, item number 31, heard Mr. B.D. Paul, the learned senior advocate, assisted by Mr. JC, the counsel for the petitioner. So we are not going to reflect this name at this stage. Your name?
If my name cannot be shown, my lord, if subsequently, my lord, the respondents engages me, then I will appear. Otherwise, my lord, in the cause list, my name will be reflected regularly whenever this matter comes.
Mr. A. Das, the learned counsel, submitted in this regard that his name has been shown as the counsel for the respondent. As in the earlier matter, he was a counsel and the caveat was filed in that regard. But he prayed that at this time the caveat may be discharged and his name may not be reflected in the cause list. However, if the party engages you, then you are going to appear. If the party engages him, he will appear. Next problem.
Well, since we'll be taking.
This is an application. There are application under section 151 of the CPC, praying for alterations / modification of the order dated 3/5/2024, passed by this court in CRP (IO) number 139 of 2024. Issue notice to all the respondents to register DD and as usual process, and also considering the prayer of the learned counsel, prayer made by the learned counsel for the petitioner, Mr. Kumar. The justice service is also allowed. The petitioner may take justice service for all the respondents.
And we'll file our.
And we'll file their affidavit accordingly. List accordingly after 3 weeks.
On 2nd of May, subject to your call lordship's committee. 2nd May, Friday.
There are 31 numbers of respondents. Will it be?
We'll do it, madam. We'll send by special messenger. I'll file the affidavit before that.
Okay, 2nd of May.
Obliged.
Okay.
Obliged.
Caveat was the caveat discharge.
We are obliged.
Item 33.
Question matter may be taken after some time.
Pardon?
Matter may be taken after some time. Sorry, we have sent for no everything.
Sometime we cannot say one matter is going to be heard from election matter. It will take them up to
within 5-10 minutes.
No, we are not on that. Okay, then for time being we are keeping it. Yes.
34.
May I please, your lordship?
Yes.
The FI lordship will find on page 15, lordship.
15.
Lordship.
Yes.
Here, my injury report was called for, my lord, regarding.
Lordship, what happened?
But my lord, as per the communication received, my lord, that report is not yet ready, my lord. From
What
that,
kind of what thing?
that injury report of the victim, my lord, because one person, my lord, he is the police personnel, my lord, he was, my lord, he was dashed with a vehicle, my lord, by the accused person's, my lord, and he received injury. So that injury report was called for, my lord, but as per communication received, my lord, that injury report was not ready, my lord.
Not yet
Not
corrected by
yet
them.
ready, my lord.
Not yet ready.
Not yet ready.
Lordship will kindly see it is my driver took my vehicle, Lordship. The vehicle was registered in name of my wife, Lordship. I being the husband, Lordship, the police came in charge of the vehicle and thereafter arrested me, Lordship. And I have disclosed everything, Lordship, that on last occasion also from CD it reflect, Lordship. I have given the name and address of the driver, Lordship. He is, Lordship, absconding now. Police could not arrest him. And the Lordship, I'm behind the bar for last 37 days, Lordship. Being the husband
No,
of the.
otherwise, obviously injury report is not there, but his involvement, can you tell us his involvement? Because he is saying that he is the owner of the case, driver, sorry, owner of the vehicle. And it was driven by his driver.
And since long, 3-4 days has gone, Lordship, that the injury report could not be obtained, Lordship. Otherwise, something details could have been forwarded by the police, Lordship, which is in Udalguri district itself, Lordship. The district is not so big one, Lordship, that the police could collect it, Lordship. As per we assume that, Lordship, so no such injury might be there, Lordship. That is why the injury report is not said. And moreover, I have already disclosed the name and particulars of my driver, Lordship. Even in my petition also, in the statement also, it reflects, Lordship. On the last 2 occasions, Lordship, the landed PP have submitted from the case diary, Lordship. 37 days, local person, no chance of absconding, Lordship, may only being the husband of the registered owner, Lordship. That is my offense, Lord. And because liability regarding my driver, Lordship, whatever he have done, Lordship, but he can be.
Your wife is a registered owner.
Lordship. Police can that part as police has done right thing, Lordship, did not pick up my wife, he have taken me, Lordship. That is the only thing, Lordship, that has been. I'll be thankful to the police kindness, Lordship.
Have you enclosed here the forwarding report?
Lordship?
Forwarding report?
Forwarding report is enclosed there. Page 21 is the forwarding report. I have typed it also, Lordship. The original is on page 21. And the RC also, Lordship.
So you want the FIR and accused?
No, Lordship.
Now, I get page 21, why it says that FIR named accused?
The police has wrote, but the FIR, Lordship, will say FIR, no name has been reflected, Lordship. He fled away, Lordship, the driver. He injured a person, Lordship, and there was a allegation that he lifted some goat to keep in the vehicle, still one goat, and he tried to keep it in the vehicle. When they raised him, Lordship, he tried to flee away. One landslide of that campus tried to stop him, but he hit him and ran away, Lordship. Fled away, Lordship, with the vehicle. That is the allegation of the.
Why he has to play the way, man? Just say Lordship may kindly see one
That
statement.
is actually in the FIR itself.
One statement.
That is the reason.
That is the reason, madam. Statement of the accused. Why he has played away, madam, and how.
Yes, you want to divert to
Divert. That is the fact, madam. And there are witness to the incident also. It is not that, my lord, as per the submission, my lord, that being a registered owner.
No, I'm not saying that, Lordship, but I was not present in the vehicle, Lordship. Allegation might be there, that will be proven or that different apart, Lordship, that is different thing. But I was not present in the vehicle,
The
basically.
goat was also recovered or what?
They could not, my lord, because
Or they could not?
yes, my lord. They tried to plead thereafter, my lord, the vehicle test in the gate, my lord.
And injured one person, Lordship, as per the reveal from the FIR, but they
tried
did
to-
not
they
disclose
tried to
me,
catch
Lordship.
They tried to catch the vehicle, my lord. So he gets the vehicle and he.
But these two person, they did not disclose me, Lordship, kept the vehicle, police came and thereafter the thing started, Lordship. There it came to my knowledge. But I have given details, Lordship, that reveal called the case diary might be also, Lordship, because on last two submission, I have heard it, Lordship, that you have stated the name of the driver and the co-person, Lordship, who took the vehicle, Lordship. Now the basic allegation is regarding, Lordship, that injured part, Lordship. As
But
I was,
Swami, this present FIR is lost in regards to the injury caused by someone.
Not only the injury, my lord, there are sections attributed are, my lord.
only kindly see the
Here, my lord, the 303, 333, 109, 61.
that regarding injury only, Lordship.
Is there any allegation of theft here? Theft
Yes,
is
madam.
also
No,
there.
they have said, Lordship, lifting of the when
Lifting of
keeping in
the-
the vehicle, and when he tried to stop the vehicle, they fled over by hitting their person, Lordship. That is the allegation, Lordship.
303.
Everything would been sorted out if they had been caught, Lordship. I was not there in the vehicle, and the theft allegation would been have also been proved, Lordship. The only thing is that the vehicle could not be.
3031 is the theft, but 3032 is punishment for theft. That is why.
Now
Main
we are-
allegation, madam, they came to theft of the roads, madam. And you will find from that statement of their modest, madam. At that point of time, they were, madam, they police tried to apprehend them, madam. Then
Campus or
the campus.
campus or police. Lordship, 37 days, Lordship. On that, I have given all the details regarding the driver and that person, Lordship, who took the vehicle. They will be tested out, Lordship, but in the meantime, Lordship, already 37 days, Lordship.
Heard by Mr. S. Muni, the learned counsel for the petition. Also heard Mr. Antti Goswami, the learned additional people appearing on behalf of state respondent. CD received, but it is submitted by Mr. Goswami that the injury report of the victim was called for, but it is not, it could not be sent by the IO as the same is not yet ready for to submit, to furnish. After the send application to লিখে দিব আবার। Mr. Moni, the learned counsel for the petition submitted in this regard that the injury report is awaited for since last 2-3 occasion, and till that the IO is not in a position to furnish the injury report. Mr. Munir further submitted that the present accused petitioner is the husband of the registered owner of the vehicle, and he has not committed any such offense as alleged in the FIR. He already cooperated in the investigation and disclosed the name of the driver and his particulars, and is still ready and willing to cooperate to further investigation of this case. Next, Mr. Goswami, the learned additional PP submitted in this regard that it is not a case that he is only the husband of the registered owner, but he is fully associated with the theft of the goat, etc., which were and the offense was etc., and he used to bring those theft goats to his shop and used to sell the meat. Mr. Goswami further submitted that the accused petitioner's involvement in committing theft is involvement in the alleged offense. No, sorry. Submitted that from the materials available in the case diary, it is seen that the present petitioner is very much involved in the commission of theft of goat. Accordingly, he submitted that further custodial interrogation may be required to for the proper investigation of this case. Next paragraph, considering the entire submission made by learning counsel for both sides, role played by the present petitioner, and for custodial detention of the accused for last 37 days, I find that further custodial interrogation may not be required for the interest of the investigation. However, the petitioner will cooperate the IO in further investigation of the case and will appear before the IO as and when his cooperation will be needed. Accordingly, it is provided for you. Okay, will be granted bail.
Satisfaction of CGM Udalguri,
CGM Utal.
in bracket they are given BTR and Assam.
CGM Utalguri, packet of BTR, Assam.
Okay. Much obliged, your lordship, much obliged.
Right, madam, we have received the service report, madam. Yeah, the service is complete, madam.
Service is completed.
Lordship,
CD have received?
CD we have received.
Lordship, considering the health condition of the present petitioner, Lordship, yesterday, I made a mention with your Lordship, and your Lordship was pleased to prepone the matter from 21 to today, Lordship. So I have annexed the medical certificate of the present petitioner, Lordship. He is suffering from chronic liver ailment, Lordship. And the symptom of this ailment is that what happens, the gallbladder becomes smaller and harder, Lordship. I have checked the medical term also, Lordship. This is the main reason I have made mention yesterday, Lordship. And since the date of arrest, as on today, he is behind the bar for the last 25 days, Lordship. It is offense under section 75(2) and section 12 of POCSO, Lordship. 75(2) is maximum period of detention is maximum punishment is 3 years, and so is section 12 also. Is behind the bar for the last 25 days.
Medical documents, Royce Farm.
Annex of 4 also. The Annex of 4 is page 15 also. The details of the ailment has been written below also. Since then, he is under treatment also. I have checked the medical term that has been mentioned in the impression logic. What I found that in this, apart from the liver infection, the gallbladder becomes smaller and harder loss. So he requires specified food and proper care loss. That is lacking inside jail loss. And since the date of arrest, he is in judicial custody loss.
Directions can be issued to give the proper care, man. Otherwise, man, it is fixed on 21(4), man. It can be disposed of on
No,
that.
it was a prayer made by Mr. Das yesterday.
Yes, yes.
For the health condition only.
Someone has to be appointed, my lord. So today it might not be possible, man. Even otherwise also, man.
Lordship, can I take a special privilege for tomorrow, Lordship, if an amicus can be appointed, Lordship, tomorrow, if it can be considered, Lordship. Or keeping the bail for final disposal, Lordship, can he be released on interim bail, Lordship, considering the health condition, Lordship?
Mr. D does still and it comes. Otherwise, what is your CD says?
CD is, my lord, implications are there. The victim is of only 5 years old, my lord. Yes, man. So, my lord, regarding bail, man, I have serious of this.
So 5, 4, 5, 3, 1, 2 years of girl is also not.
For any good reasons, he is, my lord, behind the bars, my lord. He remains, my lord, he has to.
So he should have taken care of his health. Why she is working for all these things?
My instruction is that nothing as such happened, Lordship. It is purely out of certain grudge and enmity it has been because
that is your submission.
The case has been projected and a minor girl has been used by the family, Lordship.
Heard Mr. Dita, the learned counsel for the petition, and also heard Mr. MP Kuswami, the learned additional PP, appearing on behalf of state respondent. So this is an application under section so and so in connection with so and so. It is submitted by Mr. Kuswami that the service is already completed on respond number 2. However, no one has represented respond number 2, and accordingly, he prayed for appointment of an amicus to represent the respond number 2. However, CD is already received and parents disabled. Next para, Mr. Das, the learned counsel for the petitioner submitted in this regard that the health condition of the present petitioner is deteriorating as he is having chronic liver disease along with the symptoms of hardening his gallbladder. Gallbladder. He further submitted that being a liver patient, he needs some special care and food which is not available in the jail premises, and accordingly he prayed to allow him to go on bail especially on the ground of medical on the medical ground. Next para, Mr. Goswami submitted in this regard there are sufficient incrimination against the present petitioner and and considering the materials available in the case diary, his prayer may not be considered at this stage. Further, he submitted that the victim is of only 5 years of age, and she has fully implicated the present petitioner. Next para, considering the entire submission made by the learned counsel for both sides. And without going into detail of the merit of the case, only considering the health ground of the present accused petitioner, I find it a fit case to extend the privilege of interim bail to the present petitioner till the appointment of an amicus or till next date of listing. The registry is also hereby directed to appoint an amicus to represent the respondent number 2. CD, you are going to retain the CD or let it send back?
Lordship is fixing on my lot on.
Multiply, I'll say on May, I think. May. May, then it can be returned, I think.
Okay, we can send back this.
Send back the case diary and call for an up-to-date one. আৰু বাকি তেখেতৰ provided কৰি দিব, list the matter accordingly on 9/5 can be 9/5 any matters then after 13/5 will be fixed for so and so. Further, it is provided for reply তেখেতক দিব. So whose satisfaction this one is?
To the satisfaction of the special judge, district judge Bishwanath.
This special judge
come district judge Bishwanath.
Special Judge Bishwanath, Bishwanath Chariali, and the petitioner is hereby
One
direction can be given or what?
one prayer may let him surrender after a certain period manner. Because for the treatment only your lordship is providing.
Till 13 he on
Then can create another issues. So let it be till 13 he can surrender. Or 13 if it is extended is otherwise he will surrender.
Yes.
Then till 13 his interim will be till 13th.
Yes.
The petitioner will be at interim bail till 13/5/2025. That is till next date of listing.
That's I'm blessed.
Lord, in the last order, Lordship has already taken note of the facts. Now, my Lord, I'm just placing that order which has been passed by the court of appeal. My Lord, the trial court itself has taken note of everything. On 5/4, my Lord, this was the order which was passed by the learned CJM Morigaon.
On 5/4.
Yes, my Lord.
Yes.
Accused person, namely so and so, has been produced before the court after completion of 2 days of police remand. Seen the prayer of so and so, praying for in 3 days police remand was prayed for. Then kindly come to the my Lord last prayer.
learned additional PP has submitted that during interrogation, the accused person has revealed that all his tweets were based on some contents published in various books, which he had read earlier and which he has kept at his residence. That apart, there are some other electronic devices which may be available at residence of the accused person, for which it is necessary that house search may be made by the police team in presence of the accused person. Accordingly, the learned additional PP has prayed for allowing 3 days custody, police custody of the accused. Learned's defense counsel, on the other hand, have submitted that 2 days of police custody is sufficient to interrogate the accused person, and if the accused person has revealed or relied on any such book, same can be procured from market as well as can be provided by family members if required by the IO. Learned Defense Counsel submitted in such small matters, keeping the accused person for prolonged police custody is not necessary, and as such they prayed for rejection of the prayer of the police custody and to send the accused to judicial custody. It appears that case pertains to certain statement made by the accused person against Brahmin community, which were allegedly inflammatory to flare up communal tension in the society. Regarding the purpose for which IO has sought for police custody, I am of the considered opinion that IO can still recover those material even in absence of the accused person. Further, since the electronic device mobile through which the accused person used to allegedly make the tweets has reportedly already been seized by the IO in North Lakhimpur PS, IO can re-seize those electronic devices in this case also. For that purpose, custody of the accused person is not required. Under such circumstances, I am of the considered opinion that the further police custody in the light of the investigation carried out by IO is not required. Hence, prayer for police custody is required. So, my lord, ground for that there is no requirement of custodial interrogation. It is made out from this order itself, my lord. I am not even going to the other aspects, my lord. That my Twitter X handle is so and so. It was so-called, my lord, it was from vengeance, which doesn't belong to me, etc., etc. So therefore, it's a fit case, my lord. It should be enlarged on bail because this order itself makes the rather creates the ground for enlarging the petition on bail. And my lord, it's a very serious matter, my lord. End of the day, how they are playing with the liberty of citizens, my lord, on some the ground. 8 months on 10/8/2024, the alleged things were published. And in the FIR also, my lord, what was annexed was the screenshots. Therefore, my lord, I think, my lord, he should be allowed to go on bail, my lord. And in fact, in the earlier case, he was arrested on
15th March.
15 March. So, my lord, from 15 March today, we are
26 days, 22 days ago.
almost 22 days, my lord. Otherwise, my lord, if a lordship's last order, lordship has taken note of everything. Lordship just wanted to see the case that evening. That is my humble submission.
Yes.
Lordship, here on the last occasion, I have already read out the file, Lordship. There, Lordship will see that the conduct of the petition with regard to the making of implementing statement, Lordship, he is a repetitive offender, Lordship. He makes this kind of statements once after, again, Lordship. The Lordship will kindly see page 63 also. There, Lordship will see that similar allegation was made against him, Lordship. That is also reflected in page number 63, paragraph number 4. I have already on the last occasion also I have pointed it out. Lordship. Now going into this case, Lordship, here it is not a case, Lordship, that he has done nothing, Lordship. He is absolutely innocent. That is not the case, Lordship. If Lordship and Lordship by the last order also has called for a report from the registry. It has been received, Lordship, along with the tweets also, Lordship. Lordship will find the case records, it is available, Lordship, the report from the registry. Just to elaborate, Lordship.
But we say on the last occasion,
yes,
so Chaudhary took a that this is a screenshot, in fact, Photoshop. And the tweet has been handled, his handle is already mentioned as a written thing, and but that other one is in name of the party name is a vengeance. So is there any report in that regard?
We'll kindly go to that.
Which one?
The scan copy, Lordship, there's a report from the registry also, Lordship, that was called for by your Lordship.
Yes, this one.
Yes.
Yes.
Through
Hi.
the registry.
Yeah, through registry, I have called for
Yes,
one.
yes, yes. That report has been received, Lordship, will you kindly see?
These are orders. Where from it is report? Just take it on detail. I do this. Black video.
I got it. Kindly see the tweets. For your Lordship, Ritom Singh, this photograph is also an next Lordship. That is his tweet, Lordship, his Twitter handle. And Lordship will kindly see the kind of tweets that are made, Lordship. I will just like to read a few, Lordship. Brahmins were the largest converts to Islam in India. No, they were converted.
Where from here, really?
There are a number of tweets, Lordship, you can take any one of them, Lordship.
Acha. All against Brahmin or what?
Yes, more or less, Lordship. And these are being stated without any facts.
I mean, he doesn't like Brahmins.
Yes, he doesn't like Brahmins. I don't know. Lordship. I cannot say that. But
He
saying
goes to Kamakya too often.
and it's last.
And if you are saying these are the tweets, these are the with his photographs.
Yes, that is there. And Lordship, what has happened, Lordship? His
No,
phone has-
it's okay. But all these tweets, if you see, these are most probably at the rate of seeing return. That's what I am asking, that the word vengeance are there, wherefrom we can come to a conclusion that those is there any? That's what I'm asking.
his statement, Lordship. He has
Statement.
clarified. Here, Lordship.
Yes. This is his statement.
Yes, Lordship, the first part is not necessary, Lordship. Lordship can skip to down below, Lordship. In the first part, he talks about his educational qualification. That is not required in the case. The last part, Lordship will find, or in the next page also, Lordship.
Yes.
Just Lordship will kindly go through it, Lordship.
Hmm.
He has clarified about that Twitter handle, Lordship.
These are the statement.
Lordship, regarding in the other case, Lordship, the North Lakhimpur case, his electronic device, Lordship, his mobile phone was seized. So a prayer has already been made to the learned court below, Lordship, for re-seizing those articles, Lordship. That is also in the
In here in this
yes,
case.
in the later part of the CD, Lordship. So after that, Lordship, the case will be investigation will reach to its logical conclusion, also, because they have to verify everything, Lordship. A report has to be called for, Lordship. So that is the stage of the investigation. My only thing is concern is, Lordship, if he is released on bail at this stage, Lordship, he will again commit such act, Lordship.
Because he is a habitual one.
Yes, because and he makes this kind of statement, Lordship, without there being any basis to anything, Lordship. Just making random comments, Lordship, illogical comments, inflammatory remarks, Lordship. That is the
Lord, my lord, I understand my learned friend's anxiety, my lord. Because when people are in power, they do not like criticism. Now, my lord, in a recent judgment of the Supreme Court, my lord, authored by Honorable Justice Oak and Honorable Justice Ujjal Bhaiya, my lord, has come out in favor of Article 19(1)(a). Now, my lord, all throughout in administrative law as well as in other branches of law, our understanding was the standard should be of a reasonable person. Now, my lord, in the recent judgment of the Supreme Court, the Honorable Supreme Court says the standard should be of a man who is strong enough. The standard should not be of a person who is so cynical, who is weak. Therefore, my lord, my learned friend's argument is absolutely against the order of the Supreme Court. Now, there's nothing like it, my lord. One can always express his views as long as he does not exceed that Lakshman Rekha. Now, my lord, whether he has exceeded the Lakshman Rekha, will the police officer decide or the trial court will decide, my lord? Now, is it a case where custodial interrogation is required? At least, my lord, the prayer for custodial interrogation was made by the trial before the trial court and it was rejected and rightly. That's why I say, my lord, the grounds which has been cited by the trial court, that itself are good grounds. Now, my lord, those days are gone. The standard of a reasonable man, that Witnessbury principle of unreasonableness, those are no longer there. It has to be the standard of a bold man who can withstand criticism. Otherwise, my lord, the time has come where the people's voice are being muzzled. And my lord, what the petitioner has said, these are all supported by this Ekvitatya. These are all supported by these, my lord, literatures. There are so many. The Chief Minister of the state, day in and out, he is accusing Muslims openly. What happens then? We do not have a constitution.
On politics.
So, well, I'm just making submission, my lord. Why don't you take action against the Chief Minister? Day in and out, my lord. Therefore, my lord, in my humble submission, it's a fit case, my lord, where lordships will enlarge the petition and go on bail. Day in and out, my lord, such loose statements are being made. Nobody is there to take care of anything. Therefore, my lord, my humble submission is, it's a fit case where lordships will pass an appropriate order, my lord. Deep level.
Highly right.
This is this. Oh, no, I'm not care. Bail hearing or ABE are also there. Because my Arunachal metro is also there. Election metro to এটা তিনটা পূজা টুটা রেখে দিয়ে উঠাবো বাকি যাব আর কি করব এটা এই করিয়ে বের হয়ে গেছে বাকি এই বিলিটা থেকে যাবে
33.
May please allow. In this matter, madam, on the last occasion, madam, the PP was directed to produce instruction as to whether the mandate of Vihan Kumar was complied or not. That much matter. No.
Otherwise, you have received the this one.
LCR is there.
Instructions separately, you want any instructions or
From the scan copy, we can.
you have already
No,
flagged it?
We'll just go through the scan copy and place it before your lordship, whether.
So these are the grounds you have taken.
That's but only, nothing more.
Otherwise, you weren't behind the bar since when?
Well, 5 months, 14 days, man.
5 months. This case is charged yet?
Charge.
This forwarding is Lordship 27/10/24.
20?
27/10/2024.
And that apart, what are the other grounds?
Well, that is the only specific ground, madam. It's a commercial quantity, madam.
Commercial quantity.
Yes.
Conscious possession is there or not?
There, that is their case, madam. That
No, your case?
my case is not conscious possession.
Maybe they liquid, no conscious possession, 47, 50, these are not complied with. Your petitioner's name is?
Noor Haq.
Noor Haq.
Noor Haq.
Both in arrest memo as well as 47 notice. Grounds of arrest. Both in arrest memo and the 47 notice grounds of madness is not there. Otherwise, CS is submitted when CS submitted?
During the probably on the 90th day, perhaps the charge sheet was submitted. That's why.
Anyway, within the statutory limit.
My lord?
Is it a case of commercial quantity?
Yes, yes.
So statutory okay and within statutory?
Yes, yes.
Okay. Okay, we'll pass the order.
Right.
My submission is also that it was recovered from his possession.
Position in a commercial quantity.
Regarding 47, 48 and 52 of NDPS.
52 also you are taking plea?
Probably that
52 NDPS?
Yes.
52A NDPS was not complied with?
Only 52. Because
Only 52. Okay.
Yes. Because in NDPS 52, it also says that grounds will be communicated, ma'am.
Yes, obviously.
Highly obliged.
52 NDPS so comply coronability. Grounds of arrest is not been, that means thus the 52 NDPS is also not complied with. It is whose satisfaction? Mr. Das, it is whose satisfaction? Satisfaction is whose satisfaction?
Special Judge, my lord, NDPS Dhubri, madam.
Special Judge NDPS Dhubri. Special Judge NDPS Dhubri. No?
Highly obliged.
Is about
Two ABs things no same bench as per this. Only I think 20 members. We can just fix it later.
Mr. Sharma, there are 4 ABs left.
Yes.
But we're going to hear the Arunachal matter.
Lordship.
So these matters will be left over or?
Then Lordship, item 27.
Item 27 is short issue involved. Lordship has granted interim bail on 17th March. And now
in item
number 27.
He is already on interim, Lordship.
We have already appeared.
You are on interim?
Yes. And we have already appeared. Statement has given, even the bike has been recovered by the prosecution
in
team.
item 27, you received this AD?
We have received the case diary, Lordship, but it has to be updated, Lordship. It's not up to date, Lordship. So his statement is not in the case diary.
Updated case diary be called for. As the statement of the petitioner is not available in the case record. AB 27, sorry, item 27. Call for the updated case diary. List when it can be listed? 13.5. 13.5. Till then the interim be extended.
Item number 29, this is POXO matter, Lordship. We have already taken steps, Lordship. Only thing is that Lordship may direct that PP will obtain instruction and maybe matter may be listed immediately after vacation, Lordship. Case diary is also received, only regarding that respective service. So that maybe they may obtain and immediately after vacation matter will be fixed, Lordship.
29, your service report is still awaited and accordingly the additional PPs have been asked to take instructions written regarding the service of notice on respond number 2. CD you are going to retain.
CD may be retained, Lordship.
CD is already received. Let the CD be retained till next date of listing. List accordingly when it can be.
Immediately after vacation, Lordship. Immediately after, no injury is there.
It is AB only.
AB, Lordship. There.
29, 30, we don't have any date. I think we again problem.
Because case diary is also here, Lordship. That is why I'm paying.
Okay, 30.
Obliged.
May please, your lordship. Item number 30, your lordship, we are on interim.
You are on interim.
Yes, after due vacation.
CD received here.
Yes, lordship, the CD is there and in fact, lordship, the submission based on which lordship has granted interim protection was that the person was sick. In fact, the record reveals otherwise. He had manipulated the doctor.
No,
to
no,
give us a
lordship, no, lordship, no, lordship.
Is it?
He had no, your lordship. This is completely wrong submission. He has
Let it
duly
be on-
appeared.
Let it be on 21st. If she, so submits, let it be on 21st. I got the statement of the doctor.
I have a,
Interim was granted on which date?
26th of March, your lordship. And on 2 days he was appeared on 30 March and as well as on the 31st of March.
But let us see,
And he was already suspended, your lordship.
so that is another aspect of the matter.
This is also
What was
aspect
pressed
matter
before your
because due to
lordship
this
is-
case, he was suspended, your lordship.
What was stressed before your lordship is?
No, your lordship.
That he suffered an injury, he went to the doctor and all those things. The doctor's statement lordship may take it.
We have already filed
So
our
let it be on
affidavit, your
31st.
lordship.
Let it be on.
No, your lordship.
Don't do all these things.
No, your
Please,
lordship, we have not manipulating
I
anything.
mean,
your
you
lordship.
submit genuine submission should be there,
Gen-
and we
doctor's
generally
statement is-
cooperate, and the other side also cooperating. It's not the case. Then with wrong submission, you will going to get the order and all. That should
No,
not be.
lordship,
That should not be. I'm just
no.
repeatedly saying that should.
No,
Don't
lordship.
take all these things. Okay.
Yes, we on.
Interim order be extended till next date of listing. You are going to retain the case diary or what?
The case diary on the next one.
Next date.
On
So you're going to return this one?
On
Yes, I have
second,
written it.
Return the
2nd
case
of
diary,
May,
and it is
So
so and
let
so.
it be on 21st, lordship.
no,
Twenty-
Otherwise, the evidences will perish, lordship.
Oh, acha.
no, your lordship, you already suspended, your lordship.
Okay, 21st.
How it is possible that he will tampering with the evidence? This is completely incorrect submission, your lordship.
The materials, they,
There is probability of
no,
this.
There is no probability.
we have
your lordship.
recovered a SIM.
If your
He
lordship
got
will-
an iPhone, we recovered the SIM, but the iPhone is, he has. He has got a MacBook.
Hmm.
It's not there. Gradually things are
No, your
vanishing.
if your
No,
lordship will see
on
page
21st.
number 36 of your lordship on that.
Okay, we are fixing it on 21st of
Yes, lordship.
April. Till then, your interim is extended.
Maybe the lordship. Maybe the lordship, regarding item number 28 now. Probably CD is not there. If we are on interim, that may be.
You are on interim?
We are on interim now.
Interim be extended till next date of listing.
Item 28.
CD you are going to retain, Mr. Goswami
CD
here.
is not there probably. ma'am.
Oh, sorry, CD is not there, na? Issue
28.
reminder, CD not
28.
received, issue reminder. When it can be listed? 9/5,
Interim.
list on 9/5. 9/5 corridor. And till 9/5, your interim will be extended.
Deeply.
Lordship, I beg to mention item number 38, Lordship. Lordship,
30?
38, Lordship, 38. Lordship, this I is filed for this modification of the order, Lordship. AB is disposed of, Lordship, main petition is disposed of. Before that, before this, I have filed one IA, I number 128. In there is an inadvertent mistake occurred in this PS case number, Lordship. Actually, 106 is the GR case number. Not, it should be 28 of 2024, Lordship.
So mistake after mistake you are doing.
Lordship,
Then what to do? One I was earlier there for correction. Then again for these things.
so it was an inadvertent mistake, Lordship.
So now what correction you want?
Lordship, that PS case number, Lordship, it should be 28 of 2024, Lordship, not 106.
It should be P 20.
Then I move PS case number 28 of 2024.
It will correction from Libor 28 of 2020. What order for us actually? But likha as a main petition. Today's I is of this one. 343. I is 343. Take us correction to it. Okay, we'll make a correction.
Lordship.
This item one, election petition 5 of 24, pertaining to Darbar branch.
I was number is 215, I think, na?
I will start with 214. That is an
214.
214. That is an application regarding order 6, rule 16, made it order 7, rule 11. Striking
And
out
what is 214, 215 is for
something,
this-
some
this-
sickness or mismatch and all. I will come to it one by one. First, I will start it
that is for maintainability, I think.
maintainability. So one by one, if I can complete it. Possibly subject to correction. This IA 215, I have argued.
Yes, that is you have argued.
This IA 214, I have not argued yet.
No. We have already with us. 215 to devote, na? 215.
Yes.
Let's just tell us 214 is for?
214 is for order 6, rule 16, read with order 7, rule 11. They are saying that there is no material facts and particulars, therefore which does not make out a cause of action. And if there is no cause of action under in a plane, then order 7, rule 11 attracts. So I was under
that is the issue.
that was the issue.
215, Mr. Majumdar had already argued, in fact, 215. This is also pertains to the maintainability issues. They have raised some issues there. So we can come to 215, I think, first.
Huh? 215, my lord, I'll go little slow, but I will assist your lordship. At least to the best of my ability, because I was under the impression order 6, rule 16, normally what we do. Anyway, my lord. I'm sorry, my lord. I'll just.
Yeah, it's okay.
You point to TSA. Huh? You'll correct me, huh? I'm told there are two issues in this 215. Correct me, huh? That it was not presented personally and signature.
And filing form, there was some.
These are the two issues. Very embarrassing moment. First, signature about the person. UPM. I
better sense. Time they not
215.
No need to waste time here. Go. I will take some time. And after. Say at 4, you can inform me. Time you can do your work. Well, lots of work are there also.
215. Now, my lord, to start with, side of petitions is key point of society. The representation of people act. It is framed under Article 327 of the Constitution of India. And by virtue of that article, we get the RP Act 1951. There are different parts up there, and part 6 of the Representation of People Act deals with election disputes and trial of election petitions. If I take your lordships to part 6, I'm very embarrassed, my lord. I'm very embarrassed that.
No, it is not a question of the presentation.
If your lordship look at part 6, part 6 of the RPI.
Part 6. Part 6. The same book we are holding? No.
I am holding this EBC Bear Act.
Yes, part 6.
Part 6, in fact, it starts with disputes regarding elections. Now, these disputes regarding election has been divided into different chapters. It starts from section 79 and ends with section 122, if my recollection is correct. 122.
Starts with 69.
Starts with 79.
Oh, sorry, 79.
Ends with 122. And if we look at the provisions of this particular section 79 to 122, there are certain substantive provisions, there are certain procedural provisions. As for example, regarding the filing of an election petition, it's a procedural provision. That we get in section 80A, 81, how to present it, where to present it, 82, who should be the respondent. These are provisional. These are procedural provisions. 83 is also a procedural provision because what should be the contents of an election petition. Now, 86, section 86 relates to the trial of an election petition. It says that for the purpose of trial of an election petition, how it shall be tried with. Section 86 also provides that if there is a violation of section 81, 82, and 117, 117 relates to the deposit of security for the election. These procedural provisions, if it is violated, then election petition does not need to go for trial. It can be dismissed. And there is an explanation appended to section 86. It says that if such a dismissal order will be taken as a final order passed under section 99, your Lordship will kindly see the explanation. Although it has an interlocutory nature, it has a Lordship order. The High Court shall dismiss an election petition which does not comply with the provisions of 81, 82, and 117. These are procedural provisions. And if such a dismissal order comes, your Lordship will look at the explanation. It should be treated to be an order passed under section 98. Now, section 98, if your Lordship goes to the section 98, what are the orders that can be passed? First is either dismiss the election period, or declaring the election of the returned candidate void, or declaring election of the returned candidate void and the other person elected. These are the three principal relief that your Lordship can give. Now, 86 says the order that might be passed in section 86, although it will be an interlocutory order, will be taken to be a final order. Why that provision has been made? Under 116 capital A, an appeal lies to the Supreme Court. 116 capital A. So that the appeal goes there. Now, your Lordship will kindly look at section 87. What will be the procedure for trial of an election petition? As your Lordship.
Yes.
Subject to the provisions of this Act and of any rules made thereunder, every election petition shall be tried by the High Court as nearly as may be in accordance with the procedure applicable under the Code of Civil Procedure. And thereafter it says the Indian Evidence Act will also come in. That means these two will be the governing procedures. Now, when I started with the concept that there are certain procedural sections, there are certain substantive sections. Power to dismiss an election petition or allow an election petition, as contemplated under section 98, is a substantive power of your lordship. Now, so also section 86, power to dismiss an election petition under preliminary ground, is a substantive power if there is a violation of 81, 82. This substantive provision has to be invoked by following the procedure prescribed under the CPC. Now let us look at that is what has come to my notice. I'm extremely sorry that I have not come prepared. The first cause title of the application 215. Your lordship will kindly see his application has been filed under section 86.
Yes.
It should have been filed CPC will be. On the very face of it, it should have been filed under Order 7, Rule 11. Now let us come to Order 7, because Order 7, Rule 11 comes because of the process, Section 87. Now, your lordship will look at Order 7, Rule 11. I'm sorry for wasting your lordship's time, valuable time. Now, Order 7, Rule 11, it says, the rejection of a plaint. There are A, B, C, D, E, F. If it violates the provisions of a statute, that means his contention is that I have violated the provision of section 81. He has asked for invocation of 86. Invocation is the substantive power. That 86 is the substantive power which one has to invoke through an appropriate application. Appropriate application will be an Order 7, Rule 11. The very maintainability of this application goes because if a lordship, there are procedural provisions like where to file, where to present, within how many days file, who should be respondents, what should be the contents. These are procedural provisions. That the power to dismiss or allow under 98 or 86 is a substantive power. Now, section 87 says procedure to be followed is CPC. Yes, that is the procedure. So substantive power itself cannot be an application. You should have invoked Order 7, Rule 11 if you at all want to invoke 86. The very invocation is in the application is wrong. Yes, now your lordship will come to the prayer portion also. Now for an argument's sake, let me see that what is their prayer at page number 7 of the application. Their prayer is also for invocation of 86. Their prayers would have been that for violation of section 81, lordship should invoke 86 on an application filed under Order 7, Rule 11. This is not an Order 7, Rule 11 application that we are deliberating on. Yeah, key issue was said. Affidavit. Now, your lordship, another aspect has come to me. Although at my age, I do not think I would have taken it up. I would have definitely gone into the merits of the matter. Page number 9. Before that, my lord, may I just Order 6, Rule 14. Verification and affidavit is compulsory. That along with an affidavit. Without that, no pleading can be taken into. Lordship will look at page 9. Has your lordship got it?
Yes.
Your lordship will kindly mark it. And I signed this affidavit on 13th November 2024 at UPR. Has your lordship got that? And the notary is from SEPA. SEPA notary, he is verifying a matter at UPIA, and this is what has been done. He is saying that I am signing it at UPIA. That means he never verified it in front of the notary. Notary signature is from SEPA.
But in our petition, it is SEPA.
No, SEPA is the note. I'm just, may I have the
No, no,
indulgence of
no.
passing on the
UPI is, there's a correction in our affidavit.
That means I have not been supplied with a true copy of the petition, what has been provided to your lordship. That may say, because that copy should be true under section 81, whatever is supplied to. At the UPS, it can't ship. What has been submitted to me is not the true copy, what is before your lordship. That I leave it to your lordship to, because anyway, I will place the original copy in my second limb of argument that this is what has been done. This is the original service copy. And I find this affidavit, your lordship is well aware by being in the judicial service for quite a long time. Affidavit comes at a by way of an amendment later on. The affidavit concept. Originally, it was verification, but most probably in 2002, additional requirement came in. Here, there is no verification. The application is unverified statements. Affidavit, this is verification under order 6 rule 15. Order 6 rule 15. 15 is inside, no? Order 6 rule 15. There should have been a verification supported by an affidavit. That is also missing. Unverified statement means this cannot be taken into now. The key point is yes, key point. Yes. Now, lordship will bear with me for. Now he is challenging the very presentation. When I speak of presentation, I remember chapter Roman 8, capital A of the Guwahati High Court rules. Yes, Lord. The presumption is what? Chapter Roman 8, capital A. Lordship, I'll just verify because taken aback like this, I'm just memorizing it. What exactly? Chapter 8 rule, yes. How presumption goes in my favor, Lordship will see, this is a special rules relating to filing of an election petition. These were actually why it was made special rules. The problem was because this initially your lordship is aware, election petitions were filed before tribunal, election tribunal, pre-1966. Then from tribunal it came to High Court. From High Court it used to go to Supreme Court. Now, after this amendment, now it has to be filed before High Court. Now High Court has to make a rule. So these special rules of our High Court also made. An election petition, may I read file? An election petition under section 80A of the Representation of the People's Act may be presented duly verified in the form prescribed under section 82 and 83 of the said Act before the stamp reporter, your lordship will kindly mark it. Stamp reporter with a court fee of rupees so and so affixed thereon within 45 days from the date of election of the returned candidate. On or if there are more than one returned candidate at the election and the dates of their election are different, the later of the two. Now, A is important, my lord. Every election petition shall be accompanied by, has your lordship got it? A, B, C, D. As many copies as thereof as there are respondents mentioned in the petition, together with one extra copy, all the copies being fully attested by the petitioner under his own signature, has your lordship got it? Now he says that my signature, it is not my signature. What will be the consequence? I am coming to it. To be a true copy of the petition with as many envelopes as there are respondents, bearing requisite postage stamp to enable service to be effected and registered. Then B, condition. As many printed forms, has your lordship got it? The C is an affidavit in support of the contents, has your lordship got it? A, B, C, D, there are different conditions. Now, stamp reporter, when I go, and these are the conditions. Suppose these conditions are not fulfilled, your lordship will come to note 1. Note 1. Any petition which is presented out of time, and without any of the aforementioned requisites, that means A, B, C, D, E, duly satisfied to the stamp reporter and the registry, it shall be forthwith returned to by the stamp reporter. That means presumption is in my favor that it was verified, attested in presence of him, and had it not been done, it would have been definitely returned back to me. And that next paragraph, if all these things are satisfied, then it will be placed before the Chief Justice for nominating or designating a judge to try it. That is next. Now, after that, your lordship has issued notice. Now, here I understand contention is this, that I did not personally present. And now his ground is, filing slip. In the filing slip, I'll also verify in the second round of argument. Presumption of law is in my favor. Now he wants to rebut it by another statement. I'm asking him if I'm really on the track or not. Because he's just like my younger brother. Because little in an embarrassing moment. So I was asking him, am I on the track or not?
At least 35 to 40 election petitions.
So this is like 53.
53. To my learned friend's credit, I'm still learning from him.
No, don't say that. Don't, never say like this. Because this situation every day is an experience for us. This situation I never faced. I thought I came prepared on something, and now somehow, then I was asking him that am I on the track or not? Because appearing against him also is a real honor for me.
And all these are actually on the lighter side.
Lighter side.
He's not very serious about all this.
No, about the points I'm serious. About what is the positive side of Mr. Mozumdar is, even if I want to irritate him, he'll never get it. That is what exactly I have failed in my whole career. I know him since 87 or
88.
From the 88, the day he joined, I saw him, I noticed him. And his friend is also similar. His friend was on Piquet Roy. Two similar boys joined, and they cannot be irritated. Now, presumption of law is in my favor. Now, that presumption, the burden is heavily on them to rebut it. that registry committed mistake. Because otherwise registry should have returned it to him. Because the duty of the registry that no one who does not comply with it, it will be returned for refiling. Now, how he wants to rebut, I am told that the filing slip. There is a slip called filing slip. In the filing slip, one additional statement was written by the registry that 117,000 rupees cost has been given. Yeah, he says that might be it was not given. Therefore, why handwriting? Because there is no printed clause required for that. So with this matter on 2 minutes is very unfair on my part.
And my lord is not very well today, so.
Oh.
Anyway, my lord, life is like
Okay,
this.
it should be on part of
He was
it.
telling me
Submit on the
life is
matter.
body is like a matika bhando. He was telling me outside. So I have accepted his proposition. So I was going on. So my lord,
Okay, take
but
your-
only one request from both sides. If it can be heard at Guwahati, because
That's what
obvi-
actually I am also on that day Mr. Mojumdar was arguing. So he's supposed stated that you'll be here at physical, I'll be posted most probably my roster will be at Guwahati. So just I talked that if you both are present at Guwahati, so why don't you
So
can
if
you
it,
argue
if
the
it
matter
can
at
be
the Guwahati?
recorded as a joint request from both of us,
Please
that it will be hard at Guwahati. Because traveling sometimes, my mind travels, but body does not want to travel.
We'll try to accommodate that way only.
Yes.
Otherwise, you are the youngest councillor, you are from Guwahati.
Yeah, I'm also from
So
Guwahati.
as I am most of the, I mean, roster is at Guwahati, so we'll try to accommodate this one.
You will have, next date to Possum, 25 তারিখ মানে হবো পারে।
No, only law points you are going to, you're not feeling. You're not feeling comfortable now.
In fact, I'm undergoing some treatment. In fact,
On the other day also, on your health issues, most probably time was prayed for.
actually, God, whatever God gives us, that we have to take it with a smiling face. 25th man hobo na, you know? 25th subject.
I'm no difficult. 25th it can be.
If I take this special match matter, there are many matters. If I am engaged in other than bench, then it
So
may
we
be
should know
a lighter. Or needy work,
What is it? Yeah, 28 of those.
Dollar number, it matters
28
already
over
fixed. Let those matter be there. আর বাকি ফিক্স করো বাকি আমি রেজিস্ট্রিক্ট মে কমিউনিকেশন দিয়ে রেজিস্ট্রিক্ট
29th at 2 o'clock.
29 how many members 20 No, we can ask the registry. It ownership is there. So this, but this advocates will not listen. They are pressurizing the registry also. So in this case, 29, 22 meters are there. We are going to fix it on 29, okay.
My
But,
lord.
we make a request to the registry also not to fix the list other many matters because many matters have been listed. We are in not a position even. So that is the position. Otherwise, we can, is 29 will be
It will be
convenient for
At two
Mozumdar also.
Could it be on 1st of May, my lord? Just after.
First of May to বন্ধ হয়ে থাকে level day.
No, not last. 1st of May is not closed.
Not closed for us.
Not for us. We are not. We don't fall in that category.
On
Let it be on
1st
first minute because I've got some difficulty on 29th. So many matters. Yes.
First of May
At 2
First
o'clock, ma.
2 o'clock.
at 2.
My lord.
1st of May at 2.
At
Can
Guwahati. At
facilitate.
Guwahati. Yeah.
Uh,
At the request of the parties.
okay, at principal seat.
Sorry that I could not assist your lordship.
No, it's okay. No, it's okay. Now you are not feeling well, so that is why, so we can also accommodate that.
More importantly, If I don't come prepared, then it becomes really difficult for me to make submission.
I don't know, but hearing you, I thought that you got prepared.
So I was told that it will be 214, but
And that is the beauty. That is what I tried to indicate.
because we
If-
should
if-
not, I should not waste your lordship's valuable court's time. So I was taken aback because I came from 214. Then now only I come to know that 215.
No, I thought that 215, we can hear because on that day 215.
I'll
was, and
complete my
that
215.
apart, though 214, there are some, but 215 basically regarding the maintainability, so it may be disposed of.
In fact, so order 7, rule 11 is
Yes,
also,
yes, yes.
that is also
Yes,
the
yes.
maintainability.
Obviously.
If both can be heard together one by one, and they may be disposed of together also. Because basically order 7, rule 11 is what? Maintainability.
Yes,
and
obviously,
rejection of the claim.
obviously maintainability.
At present, let it be.
More
let it
complete
remain
for you.
separate.
I will complete 215, then he will start with 214,
Yes.
then I will complete 214.
My lord.
At least these two applications can be.
Hard list, petitioner, paragraph. I to click on IA 21 of 2024. So here petitioner is Mojumdar.
I am the applicant.
Heard Mr. D. Mojumdar, Dilanet, senior advocate, assisted by Biswas, as Biswas for the petitioner oblique applicant. There you are respondent, that applicant respondent. And also heard Mr. K.P. Patel, Dilanet, senior advocate, assisted by Mr. G.S. Saikya. GJ Saikya, and A. Tatak. Tatak, you are going to return back today or you're going to stay today? Staying for only 1 day or 2-3 days?
No, I'll be going back tomorrow.
Tomorrow.
Yes.
And Mr. A. Tatak for the counsel for the Edutadio respondent / the petitioner, election petitioner back at matter part heard. Let the matter be listed on first. You're saying on 1st of May?
My lord.
1st of May?
1st of May.
1st of May 2025 at 2 p.m.
My lord.
At 2. And the request made by the senior counsel for both the parties to hear the matter from the principal seat.
My lord.
Lordship may just pass the order. Order in respect of this IA, because subsequently for
No, we are
evidence, etc., we'll have to go there.
we are passing this order in respect of 215 AP. And rest she will pass the order for
Because
that.
for the purpose of evidence, we will go there.
Yes, that is why.
Because the
this-
witnesses have to come.
Yes.
Then we have to make ourselves evident.
Witnesses will only come if
But if
So if it is there, if
but
it's
it
still there.
will from him only. The witnesses will come from witness. Lordship will only confine it to only Guwahati. Trial will be at, that is it was his suggestion.
Subject to the final order to be passed in the IA.
Now he is robbed by his own thing.
We are fully confident that
But
IA 215 will be allowed, and that will be the end of the entire matter.
I'm
Because our-
looking for an opportunity. The day I can irritate him before I fully retire, that will be the day of my success in life.
Let us see.
Deeply.
Obliged, your lordship.
You're having medicine and all. Okay.